All right. Hear ye, all who have business before the Court of Judicial Discipline, come forward, and ye shall be heard. Court reporter, you can begin now. Judge Eisenhower presiding.
Good morning, everyone. I am Judge James Eisenhower, and I'm the presiding judge in the sanction hearing today in the case of DeClaudio. Procedural background of the case is as follows. On December 20th, 2019, the Judicial Conduct Board filed a complaint against Judge DeClaudio. After several delays, Judge DeClaudio retained counsel, filed his pretrial memorandum on September 24th, 2020. Pretrial conference was held before this court on October 1, 2020, and joint stipulations of fact in lieu of a trial were filed by the parties on October 9th, 2020, with amended joint stipulations of fact filed on October 15th, 2020. The opinion and order of this court was filed on December 1, 2020. In that opinion and order, this court found that Judge DeClaudio had violated rules 1.1 and 1.2 of the Code of Judicial Conduct and Article 5, Section 17, small b, and Article 18, small d1 of the Pennsylvania Constitution. Judge DeClaudio filed exceptions to the opinion and order on December 9th, 2020, which were briefed by both parties. These exceptions were denied by this court on December 21st, 2020. Sanctions memorandums were filed by both parties, and the sanction hearing was then scheduled for today. I'd like counsel for both parties to please introduce themselves for the record.
May it please the court, my name is Melissa Norton and I represent the Judicial Conduct Board.
And Sam Stretton on behalf of Judge DeClaudio, who's sitting behind me.
Would the board now please proceed?
Thank you, Your Honor. Thank you. If you would give me one moment, I'm just going to move a podium over to be able to
Sure, take your time. Am I still appearing on the screen? Because I've disappeared from mine. So.
You are.
You see me? All right. Okay. I don't need to see myself. So to make sure everyone else sees.
I have one witness to present to the court. I believe this would be the appropriate time. I would ask Ms. Kane, is Jonathan Goldstein in a waiting room somewhere?
Yes. Would you like me to bring him in now?
Yes. Would you do that,
Okay.
please?
Mm-hmm.
Mr. Goldstein, can you hear me?
He's muted.
Yes. Would you like me to bring him in now?
Yes. Do that, please. I don't know, does that mean anything? There we go. Attorney Goldstein, this is Melissa Norton. Good morning.
Ms. Norton, when you wait, hold on 1 second, please.
Everyone can hear me.
I'd like to ask the court reporter to swear in the witness, please.
Attorney Goldstein, please raise your right hand. Do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
Good morning. Attorney Goldstein, would you just state your name for the court, please?
Yes, my name is Jonathan Shea Goldstein. I'm an attorney admitted to practice law in Pennsylvania and several other jurisdictions.
Thank you. Now, Attorney Goldstein, I'll get right to the point. Did you represent the Kenwood Club in its lawsuit against Judge Scott DeClaudio?
I did.
Melissa, you're breaking up, at least for me.
I'm breaking up. Okay.
Is anyone else having any problem hearing counsel? I am not.
I moved the microphone closer to me. I'm not sure if that will help.
Sounds better now. Thank you.
Okay. Okay. And just to make sure we're all on the same page, so to speak, are you aware that this court, the Court of Judicial Discipline, has found that Judge DeClaudio violated the Code of Judicial Conduct and the Constitution pertaining to some of his conduct in that lawsuit?
I am aware.
Thank you. Now, can you tell this court how Judge DeClaudio's misconduct in that lawsuit affected your client, the Kenwood Club?
Well, it affected my client a number of ways. First, they were affected financially. The suit against Judge DeClaudio was ultimately settled for an amount less than their damages, and less than they were entitled to based on interest and costs being accrued. They were also affected reputationally. I mean, there they were on the front page of the newspaper, a private social club embroiled in litigation with a sitting common pleas court justice. It was reputationally very damaging and economically damaging.
Thank you. Can you tell the court, did Judge DeClaudio's misconduct in that lawsuit affect your law firm in any manner?
It did. It affected us in three ways. We were injured financially. We wrote off approximately $20,000 worth of our time. I think most of the folks on this Zoom call, it's hard to tell because everyone's in a teeny weeny little box. But I think everyone is a lawyer or familiar with what lawyers do. And sometimes we have to stay in cases, even when the economics of those cases fall apart. This was one such case. We were pouring associate and partner time into this case to manage it because we couldn't get Judge DeClaudio to respond to our motion practice. And we had a client who was mystified as to why we couldn't generate a result. So we were economically injured to the tune of almost $20,000 in time that we had to write off. We were reputationally injured because our client kept saying to us, what is the problem here? Why can't you get this done? You keep telling us you're filing things, and why can't you get it done? And then this firm was injured professionally. I supervise associates and I teach CLE. And one of the things that I teach is ethics. So I teach, for example, at PBI's criminal law seminar every July in Harrisburg to hundreds of criminal law professionals across the state. And now I'm the guy that was embroiled in a dispute like this with a judge. And it's been very difficult for us. It's not been a great matter. We saw it through, but we're not happy we were involved in it.
Thank you.
I just want to recognize Judge Rangos and Judge Baranowski who joined us.
Thank you.
Good morning.
To be clear, I've been on the call from.
I don't know if you can see him, but Judge DeClaudio is seated behind his attorney, Mr. Stratton. Other than today, have you actually seen Judge DeClaudio anywhere?
I sure have.
And where might that have been?
So I was in the ceremonial courtroom in Philadelphia, the Supreme Court's ceremonial courtroom, back in, I want to say 16 or 17. There was a case that had made its way through the lower courts in Pennsylvania and was before the Supreme Court of Pennsylvania. And it was a case that was of interest to my client, and they asked me to be present for the oral argument that was being conducted. I had worked very hard with them on the matter, and they wanted my view on how the oral argument went. And before the oral argument for our scheduled case, there was a disciplinary case on the docket. As it turns out, it was a disciplinary case for then attorney and judge-elect Scott DeClaudio.
So let me ask you this. You said it happened somewhere in 2016 or 2017. Is it possible that that date is incorrect?
Oh, yes. My memory as to the date is surely faulty. If you have the date in any of your documents, I would surely substitute your judgment for mine. I can't recall exactly when it was.
I believe the board has submitted a document as an exhibit indicating that this occurred in on December 10th of 2015. That would have been while when the last time Judge DeClaudio was before the Supreme Court. Attorney Goldstein, does that sound correct to you, December 10th of 2015?
Yes, that's surely correct. If that's what the official court records reflect, and that actually makes sense in terms of the timing of when I guess he must have been elected. So yeah, that makes perfect sense.
Okay, all right. So what did you observe on that occasion in 2015?
So what I observed was Attorney DeClaudio, Judge-elect DeClaudio, being disciplined publicly by the Supreme Court. And I won't verbatim repeat the testimony and the words of the Supreme Court, though I would encourage this court to obtain a copy of that transcript. It will be quite illustrative.
Objection. Objection. We're not here for what happened when he was a lawyer.
Well, sorry.
You do know what an objection is, Mr. Goldstein?
I do, and I'm realizing that I'm not.
Thank you. You can wait. You can wait for the response from the presiding judge.
Yeah.
Judge Eisenhower, your microphone is muted.
The objection is on grounds of relevance. Is that correct, Mr. Shred?
That is correct, Judge Eisenhower.
I'll overrule it. You may answer the question.
Thank you, and my apologies. In these little Zoom calls, it's sometimes hard to forget when I'm a witness and an advocate. So my apologies. I'll try to contain myself going forward. So in terms of what I observed, I saw then Judge-elect DeClaudio being disciplined publicly by the Supreme Court of Pennsylvania. The tone of the discipline was stern, and they made it very clear, and I'm not quoting them directly, I'm giving you my sense of the sentiment of it, that they were now seeing him for the third time and were instructing him that if they had to see him again, the consequences would be severe. And the room was packed. It was actually standing room only, and I was standing in the back of the room adjacent to a small knot of other attorneys who also couldn't find seats, one of whom was a junior associate who had joined my firm in the recent past, the last year or two. And as Judge DeClaudio, then Judge-elect DeClaudio, came down from the discipline, he came towards the back of the room and passed by me and my associate and the group of attorneys I was standing with. As he came by us, he turned to a person who I later learned was a reporter for one of the court reporter is waving.
Mr. Goldstein, you have to back up to as he came by me. Just slow down a little bit because with Zoom, if you go too fast, it cuts the voice out. Thank you.
My apologies. Let me go back then. As he came by me, am I speaking slowly enough now? Okay, great. As he came by me and my associate, I heard him speak to a person who I later came to know was a reporter for one of the legal publications in Philadelphia. And as he went by, he waved at that person and said loudly, "Well, I guess it's time to go be a judge," and walked out of the room. And my associate looked at me, and a few of the other lawyers in the knot standing near me looked at me, and several of them shook their heads. And my associate was essentially panic-stricken, like, is that a thing?
Objection.
What's the grounds for your objection, Mr. Stratton?
Totally irrelevant and hearsay what his associate's doing. Speculative.
I'll sustain the objection.
So if you'd like, I can tell you my reaction, which was that I was...
Objection. His reaction is relevant to these proceedings.
I'll overrule that.
So I couldn't believe it, and still can't believe it, and I would encourage you to get the Supreme Court transcript.
Attorney Goldstein, did you have an impression when you heard the judge say time to go be a judge? Did you have an impression of whether or not he was saying that seriously or in a joking manner?
Objection.
Sustained.
Let me ask you this. Did Judge DeClaudio, was he smiling when he made this comment?
Objection and leaving.
Overruled.
He was smiling, and he wasn't contrite.
Objection. Move to strike, wasn't contrite.
Overruled.
Okay.
Thank you. I have no further questions for you, Attorney Goldstein.
I have a few with the court's permission.
Certainly.
Good morning, Mr. Goldstein.
Good morning, Mr. Stratton. Nice to see you again.
Nice to see you. Sorry under these circumstances.
Indeed, me too.
The amount at issue, though, for the athletic club is about $1,300. Am I correct?
So the underlying amount was a debt of approximately that, and then ultimately interest was placed on top of it, because you recall there was originally an MDJ matter that Judge DeClaudio appealed and then never responded to, and then the rest of it was attorney's fees, and actually there were 3 or 4 separate sanctions awards that comprised part of that, and the sanctions were awarded after hearings in open court where we were allowed to testify about the amount of time we had spent trying to get Judge DeClaudio to comply
Mr.
with
Goldstein,
court orders.
Mr. Goldstein, I think the question was about the amount that in controversy. Was it $1,300?
The underlying amount was $1,300, yes.
Was that the question, Mr. Stratton?
It was, Your Honor.
Okay, next question.
The case was settled finally by Judge DeClaudio for approximately $9,500. Am I correct?
I accept your math. That sounds like just about the right amount.
And as I understand it, I'm sorry, I couldn't hear what that was. Someone was saying something.
No, I think it was just a glitch.
Now, Mr. Goldstein, your firm has taken some controversial cases over the years, am I right?
Yes, of course.
And in fact, you represented Mr. Trump on claiming that his election was stolen in Bucks and Montgomery County in the recent election, am I right?
Your Honor, I'm going to object to this line of questioning. I don't understand its relevance to how Judge DeClaudio's misconduct affected Attorney Goldstein and his firm.
The only relevance is that if he says his firm's reputation was hurt, I thought it might be, at least the court should be aware there were other issues that could have affected the firm's reputation.
Objection is overruled.
So we take controversial cases quite regularly, but we take them, generally speaking, in a several narrow areas. We represent political candidates and political parties. We represent nonprofit groups. And so when I say our reputation was damaged, I pay no mind to the people that disagree with the cases we take ideologically. When I say my reputation was damaged, it was my reputation for my ability to be effective and generate a result. When after filing 4 contempt motions, I can't get somebody to come in and be a witness in a proceeding that I'm handling, that's reputationally damaging, not the content of the matters we take.
Mr. Goldstein, all I asked is, did you handle those suits alleging that the election was stolen and making accusations about the Bucks County and Montgomery County voter services? You did that, didn't you not?
I'm sorry. Mr. Stratton, that seems to be very far afield, at least from my viewpoint. I'm not sure where you're going with it, but I
believe it's been asked and answered. So, Mr. Stratton, if you could move on.
I will. I have no other questions.
All right.
I'm not going to get.
Thank you, Your Honors. I have no further questions for Mr. Goldstein.
Anything further, Ms. Norton?
No, I have nothing further. No further questions for Mr. Goldstein, Your Honors.
Thank you.
I thank the court for the opportunity to testify today.
Thank you.
Certainly. You may step down.
Now, Your Honors, the board has no further witnesses. I will admit that I'm not certain what the next point in this proceeding should be. Am I to move into my argument, or would the court first like to hear Mr. Stratton's witnesses?
I think we'd like to hear Mr. Stratton, if you're resting, and then have closing arguments on both sides.
Thank you, Your Honor.
Mr. Stratton, you may proceed.
Thank you very much. Our first witness will be Attorney Brian McMonagle. That's McMonagle. He's there. He should be in the virtual room.
He's on here if somebody wants to give him the oath.
Where is he?
Can the court reporter please swear in the witness?
Mr. McMonagle, I'm sorry. Would you please raise your right hand? Do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
Good morning, Mr. McMonagle. Sam Stretton questioning you.
Good morning, Mr. Stratton.
Sorry you had to be sworn in. I remember when Judicial Inquiry Review Board would never swear in an attorney or a judge, but those days are long gone.
That's okay with me.
For how many years have you had the privilege of practicing law in the Commonwealth of Pennsylvania?
Since 1984.
And currently you have an active practice emphasizing criminal law in the city of Philadelphia?
Yes, sir.
Now, do you know my client, Judge Scott DeClaudio?
I do.
And for how many years have you known Judge DeClaudio?
A few decades. I've known Scott since he was a young assistant district attorney in the Philly DA's office, and obviously from that time forward. So a long, long time.
And over the years, have you had occasion to see him when he was a practicing attorney and observe his skills as a lawyer?
Yes. After he left the district attorneys, while he was an assistant district attorney, I had cases, I think preliminary hearings with him. And then when he left the DA's office, we actually tried several cases together. One high-profile case in particular comes to mind, but several cases. And I've observed him as a trial lawyer and consider him to be, have been an excellent trial lawyer.
And over the years, until he was given the privilege of election to the bench, did he try many cases, particularly criminal cases, to jury and non-jury verdict?
He certainly did.
And was he a diligent lawyer, to your recollection?
Yes, he was. I tried several cases with him, and I found him to be an outstanding trial lawyer.
And as a trial lawyer, did Judge DeClaudio attempt to improve the legal system by trying to set up a second public defender's office to move cases prior to his election to the bench?
I'm going to object to this line of questioning. As Mr. Stratton had said earlier, his conduct as an attorney is not the subject we're here about today. I thought these witnesses were going to be testifying about their knowledge of the judge.
I think you opened the door to that questioning, counsel, so I'll overrule your objection.
All right.
Mr. McGonigal, do you need me to repeat it, or do you remember my question?
I do remember it, and I don't have a lot of memory of it, but I do remember that he tried to do precisely what you've described.
Have you had the occasion to appear before Judge DeClaudio since he has been elevated to the bench in January of 2016?
Yes, sir, I have.
And could you describe what kind of judge you have observed Judge DeClaudio in his courtrooms?
He's an outstanding jurist. I can say without hesitation or pause, he's one of the best judges I've ever had the privilege of appearing in front of. He is smart. He is fair. He is balanced. He provides an even playing field for defendants. He has always respected the dignity and the rights of victims of crime. He respects the lawyers that appear in front of him. And I know among my colleagues in the criminal defense bar and some of the veteran prosecutors that I am still friendly with, he enjoys a remarkable reputation for somebody who gets it right. And while I've not always accomplished what I wanted to in front of him in defending criminal clients and gotten what I wanted, I have always left his courtroom believing that he got it right as a citizen and as a practicing lawyer here in Philadelphia. He has taken what he learned as a trial lawyer and brought it to the bench. And he is a tremendous asset in the Court of Common Pleas. And for those who haven't had the privilege of appearing down in Philadelphia, being a judge in Philadelphia is no easy thing. Tremendous volume, high lists. It can be chaos at times, and he does a tremendous job. And particularly now with the pandemic, I truly hope that, on balance, we get to keep him because we're going to need him.
Is he a highly productive judge in terms of moving cases, if you know, Mr. McGonigal?
I do know, and I don't know that he has many peers in his ability to move cases, but to move them fairly. I've watched him, when you go into that courtroom, you may be one of 30 lawyers in there. So you're in there, and I've watched him dispose of cases, handle cases, multitask, and he gets it done. In the courtroom, Scott is,
sorry, we lost you. There was some kind of noise. That's okay. Tell me, how does he, when he moves cases apparently rapidly, how does he treat the litigants before him? Is it quick, or does he have or you describe what your observations are?
well, I mean, Scott, Judge DeClaudio, he knows many of the litigants that appear before him because he was one, and he is always cordial. He's collegial. He's at times brings humor to it, and yet when it gets down to it, he can be enormously productive and fair. I've never watched him handle a case in which he's disparaged a lawyer. I've watched him handle prosecutors and defense lawyers alike. And I think he goes out of his way, quite frankly, to be fair to both sides because he has served on both sides.
You know people in the legal community and community at large that know Judge DeClaudio?
Yes.
Among the people you know in that community who know Judge DeClaudio, who you have spoken to, what is his current reputation as a peaceful and law-abiding person? Is it good or is it bad?
It's good.
And similarly, what is his reputation among those people, his current reputation as a truthful and honest person? Is it good or is it bad?
It's good.
You, as a practicing attorney who knows Judge DeClaudio for these many years, and knowing the allegations and why we're here, do you have any hesitation in recommending to the Court of Judicial Discipline that Judge DeClaudio should continue to serve as a judge in the Court of Common Pleas?
I do not.
Thank you, Mr. McGonigal. Your witness, Ms. Norton.
Thank you, Mr. Stratton. Permission, Judge. Attorney McGonigal, you've indicated that Judge DeClaudio has a reputation for being a law-abiding citizen. Is that correct?
Yes.
Are you familiar with the violations that he's been found to have committed as a judge? Specifically, his failure to obey various court in the Kenwood Club lawsuit.
Your voice broke up a little bit. I'm sorry.
I object to the question. When you are asking someone's character, you don't ask them, well, is he a bad character because of what he did? It's his reputation in the community.
It's overruled.
I'm sorry. If you could just repeat part of your question trailed off, and I didn't hear some of it. I apologize.
That's quite all right. My question to you is, first of all, you've indicated you know him, his reputation to be a law-abiding citizen, correct?
Yes.
Are you familiar with the violations that he committed related to the Kenwood Club lawsuit?
Yes.
Are you familiar that some of those violations pertain to multiple court orders which he ignored, resulting in him being found in contempt of court?
Yes.
And you believe an individual who has been found to be in contempt of court on multiple occasions is a law-abiding citizen?
Objection. It's not his belief, it's a community reputation in the community. Pennsylvania, you can't give your personal opinion.
I'll sustain the objection.
Do you believe that his reputation in the community has not been affected by the fact that he violated several court orders involving the Kenwood Club lawsuit and was held in contempt of court on several occasions?
I can only tell you what his reputation is among the folks that I know that know him. And among those individuals, mostly whom are practicing lawyers, it has not affected his reputation of being a law-abiding citizen among them and with me.
So these would be individuals who are your friends and associates and Judge DeClaudio's friends and associates. Is that correct?
These are practicing lawyers who are some friends of mine, some no particular friends of mine, but practicing lawyers that I work with, sometimes side by side, day by day, who believe him to be an individual of good character. I can't speak for the entire community, just those folks that I do know.
No further questions.
I have no further questions.
You're excused, Mr. McMonigle. Thank you.
Thank you, Your Honor.
Next witness, Judge Eisenhower, excuse me, is Shaka Johnson.
But I want to ask Mr. McMonigle a couple of questions, if I could.
Oh, no, I have no problem with that.
Certainly.
McMonigle back.
It's a little hard to juggle all these boxes. I apologize.
I believe he signed off already.
Yes, it appears Mr.
We can
McMonigle
get him
signed
back.
off.
I will get him back if you give me a minute. We'll just ask him to come right back on. We're texting him right now. While we're doing that, you want to bring the next witness on, and then we can interrupt him if we get Mr. McMonigle?
That's fine with me, Mr. Stratton.
But we will get him back. We just text him.
Okay.
And as soon as
Any
he-
time
Okay.
during the hearing would be fine. Thank you.
and
You can proceed with your next witness, Mr. Stratton.
that would be Shaka, Shaka Johnson, Johnsson, an attorney. Mr. Johnson, are you there? Oh, there you are. I see you. Sorry about that.
The court reporter, please swear in the witness.
Mr. Johnson, would you please raise your right hand? Do you swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Before we start with Mr. Johnson, we have Mr. McMonigle back in your virtual room. Do you want to just bring Mr. McMonigle on for the questions of Judge Schwartzman, and then we'll question Mr. Johnson?
Sure.
I will be brief. Judge Eisenhower, may I proceed with my question?
Yes. Let me just make sure I see Mr. McMonigle that he's appearing.
Yes, Your Honor.
I see.
You're still under oath, sir.
Yes, sir.
Good morning, Mr. McMonigle.
Good morning, Judge Schwartzman.
I just want to make sure that I understand and the record is clear. Knowing the underlying facts that caused these charges to be brought against Judge DeClaudio, did I understand your testimony, and is it your testimony that you unhesitatingly support him continuing as a judge on the Court of Common Pleas of Philadelphia?
Yes, sir, I do.
Thank you. I don't have anything further.
Any other questions for Mr. McMonigle? Seeing none, you are now excused again, sir. Have a
Thank
good
you, Your
day.
Honor. Good day.
Thank you, Mr. McMonagle. Now we need Mr. Johnson back wherever he may have gone. Oh, there you are, Mr. Johnson. I forget, were you sworn in, Mr.
I
Johnson?
don't believe we got to that. Can you please swear the witness, court reporter?
Your Honor, we did swear in the witness.
All right, you may proceed then.
Good morning, Mr. Johnson. Give us your full name for the record, if you would.
Certainly. Shaka Johnson, S-H-A-K-A, last name Johnsson.
And Mr. Johnson, you've had an interesting career. You started as a police officer, am I right?
Yes, sir.
I was down in, was it South Carolina or North Carolina?
Georgia.
No, I was close. And for how many years have you had the privilege of practicing law in the Commonwealth of Pennsylvania?
10 solids, 10 straight.
And you currently have a very active criminal and civil practice in Philadelphia and the surrounding counties?
Yes, sir. More dedicated towards criminal.
Now, over the years, have you gotten to know my client, Judge Scott DeClaudio?
Yes, sir.
And did you know him as a lawyer or just as a judge?
More so, honestly, as a judge. In passing, when we were both, when he was a practitioner, really in passing, but more so since he's been a jurist.
Could you explain whether or not you have ever been in Judge DeClaudio's courtroom? And if so, describe his demeanor and how he runs his courtroom.
Yes, sir. I have had the occasion since Judge DeClaudio became, in fact, a judge, to be in front of him on a lot of occasions because he was assigned to what is known as the smart room, where I guess is sort of a triage room for many of the criminal matters that matriculate to the Court of Common Pleas level. So many of my clients, regardless of where their case ended up, we had to go through Judge DeClaudio's room. I can tell you, Mr. Stratton, that having traveled, practicing from Philadelphia all the way to Erie County, and most counties in between, practicing in the state of New Jersey, from North Jersey down to the shore, I've had an opportunity to vet and just sort of watch and assess jurists of all different types. I find Judge DeClaudio to be exceedingly equitable and fair-minded in his dealings. He is neither, in my opinion, pro-defense or pro-commonwealth. He is, in law school, they talk about the reasonable man and how that's sort of a standard that you hardly could ever achieve, but we reference it always, the reasonable man. In my opinion, the way in which he runs his courtroom is how I'd always imagined a judge would be. You don't always get what you want or what you desire, but you have an opportunity to speak, to feel as if your thoughts and your arguments are being heard. They are not dismissed and done so in sort of a dismissive or a negative fashion. They're thought out, they're vetted, and I'm speaking about both sides, whatever side of the aisle you're on. This has been my experience to watch and listen, not only to my cases, but the cases that have been before me when I'm waiting for my case to be called. It's the sort of place that, when I say the place, I'm talking about the room that he presided in. It's the sort of place that you wish every courtroom was like. It's the kind of place that your client, win or lose, prevail or not, or somewhere in between, feels like his attorney was heard, and then Judge DeClaudio has a knack for speaking directly to the clients themselves. And so the client feels like their thoughts were heard. And when we leave, there's really, it's difficult to be angry even when you don't get what you want. It's difficult to feel like you may be disappointed because your position wasn't particularly advanced. but it's very difficult to be angry because it's such a thought out and all the things are put on the table. His thoughts, his reasonings are put on the table for you to consider. So even if you disagree, even when you disagree, you at least understand where the court is coming from and your client understands where the court is coming from.
Mr. Johnson, have you gotten to know people in the legal and community and the community at large who know Judge DeClaudio?
Yes, sir.
Among the people you know who know Judge DeClaudio, who you have spoken to, what is his current reputation as a truthful and honest person? Is it good or is it bad?
It's exceedingly good. It's what I just said to you. I'm speaking obviously for myself, but this is the sentiment in the locker room, so to speak, of all my co-practitioners and colleagues that I am in contact with on a daily basis.
What is, say among the same people, what is his current reputation as a peaceful and law-abiding person? Is it good or is it bad?
It's exceedingly good, sir.
And you as a practicing lawyer, someone who I've seen try many, many cases over the years, you've been in Judge DeClaudio's room a number of times. Do you have any hesitation in recommending that Judge DeClaudio be allowed to continue as a judge on the Court of Common Pleas based on your knowledge and experience in his courtrooms?
No hesitation whatsoever, Mr. Stratton.
Witness, Ms. Norton?
Thank you, Attorney Stratton. I have no questions.
Any other questions for Mr. Johnson?
Who?
No further questions for Mr. Johnson? Thank you, sir. You may be excused.
Thank you, Your Honor.
Thank you, Mr. Johnson.
You're very welcome.
The next witness will be Damian McLaurin, McLourin, an attorney and public defender, Philadelphia County.
Judge Eisenhower, this is Joe Metz. I'm with the computer guys, and they ask if it would be possible to mute your microphone except when you're speaking. Apparently, they're picking up some interference there.
Okay.
Okay, thanks.
Mr. McLaurin, are you present? I see your name, but I don't see your face. Need some more water. I'm sorry, I forgot about it.
Yeah.
I'm sorry.
No,
Is Mr. McLaurin not available?
yeah.
My daughter's in her upset.
Do we know if Mr. McLaurin is present? We can move on and
We've got other witnesses. I
wait for him. I know you have other witnesses, Mr. Stratton.
This is Kathy Kane. He's logged on twice, but he apparently doesn't have any audio.
Well, we will, if he does get audio, just let us know. Our next witness I would like to call is retired Judge Chris Wogan, Wogan, and he should be in the virtual room.
Dave's up there, I think.
Hello.
Oh, where's she? Oh,
Daughter in second.
oh, we have the judge's daughter. If she's on, I'll call her next, and then we'll get Judge Wogan when he appears, if that's all right.
That's fine, Mr. Stratton. Court reporter, will you please swear the witness?
I'm sorry. Would you raise your right hand, please? Do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
All right, good. This is good afternoon, Mr. DeClaudio. Nice to talk to you.
Good afternoon. You as well. Nice to meet you.
And give us your full name for the record.
Gabrielle Emma DeClaudio.
And what is your relationship to my client, Judge DeClaudio?
I'm Scott DeClaudio's daughter.
And I understand you had a big graduation last week.
Yes, I graduated from Penn last week with a dual degree.
And what's your degree in, out of curiosity?
So I got a dual degree from both Wharton and the College of Arts and Sciences in international business.
And you currently are working up in New York for a financial company. Is that a fair statement?
I will be starting July 7th in New York. Yes.
How about law school? You're obviously, you've known your father all his life. Am I correct?
That would be correct.
And you have been and seen him in courtroom both as a lawyer and as a judge. Am I correct?
Yes, many times.
Could you describe your father to the panel, the person you know, to the Court of Judicial Discipline? Describe the person you know.
Sure. So my father has always been a good, kind, and empathetic man. As busy as my father was running his private law practice while I was growing up, he was always there for me, participating in my community, school, and athletic activities, helping me with schoolwork daily. He drove me to school every morning from pre-K on, teaching me to spell my name, multiplication tables, and French. Even when my parents got divorced, I spent 50% of my time with my father. As far back as I can remember, even before my father became a judge, he would take me to Manna. We would work side by side in the kitchen.
Now tell us what Manna is. Some of the members aren't from Philadelphia.
Oh, sure. It's an organization that helps to fight food insecurity in Philadelphia. So volunteers go and package food daily to serve to the hungry in our nearby community.
And has your dad done that over the years, to your knowledge?
Yes, I've gone with him many times.
And you, of course, have served food to persons who need it in the Philadelphia community with your dad?
Yes.
Over the years, in terms of your dad's temperament, how has he treated people?
My dad treats people with the utmost respect and kindness in and outside of the courtroom. I've watched him address defendants in his courtroom with respect, regardless of the offense or facts. My father really, truly always has good intentions and wants to help people. And I think he's really made that his life goal to help others.
And although I think it's obvious, you do know a lot of people who know your dad, am I right?
Yes, of course.
Among the people you know who know your dad, what is his reputation currently as a truthful and honest person and as a peaceful and law-abiding person? Is it good or is it bad?
Good. I think my people would say my father's kind-hearted and altruistic, and just overall a very good person.
Now, let me ask you one more question. You know why your dad's here today and how he inexcusably acted during the civil lawsuit. You're familiar with that, right?
I'm familiar. I can't say that I know all of the details, but I'm familiar with the matters overall.
And has your dad expressed remorse and sorrow for the way he acted in that civil lawsuit, to your knowledge?
Yes.
And has he indicated that he was wrong in the way he acted in that particular lawsuit?
Yes, I think he very much is regretful for how he acted in this circumstance.
Thank you. Ms. Norton, your witness.
No questions. Thank you.
Any other questions for Ms. DeClaudio?
I have no questions.
Being none, Ms. DeClaudio, you're excused. Thank you very much.
Thanks,
Thank
Mr. Claudio.
Thank you very much.
Can we try again, either Judge Chris Wogan or Attorney Damon McLaurin? And it's retired Judge Chris Wogan.
Attorney Stratton, this is Joe Metz. I'm understanding Judge Wogan's not showing up. Is on the technical side here.
Well, we will text him again. I spoke to him about an hour ago, so we will
Okay.
get him. How about Damon McLaurin? Is his machine working now where we can hear him? Damon, are you there? I see your name. I guess it's Darn. I'm mispronouncing your name.
Sam, he's on mute. Perhaps if he unmuted his microphone.
Mr. McLaurin, can you unmute for us and say something?
Hello, can you hear me?
Unmuted.
Okay. We can hear you now, Mr. McLaurin. You have to be sworn in, as you know.
Yes.
Court reporter, please swear the witness.
Mr. McLaurin, please raise your right hand. Do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
Yes.
A video of this witness?
Yeah, I don't see the witness.
Mr. McLaurin, can you get your computer or video on?
I'm sorry. See me now?
No.
No, we don't see you at all.
If you press the start video, perhaps that would do it.
Oh, there you are.
Okay. Thank you.
We were looking for you, Mr. McLaurin.
I'm sorry, Your Honor.
We've got you now, sir. You may proceed, Mr. Stratton.
And you've been sworn in. Give us your full name for the record if you've been sworn, Mr. McLaurin.
Damon McLaurin.
And Mr. McLaurin, have you had the privilege of practicing law in the Commonwealth of Pennsylvania, and if so, for how long?
I've been an attorney for 17 years.
And are you currently employed by any organization, or are you a sole practitioner?
I'm employed by the Defense Association of Philadelphia.
And for how long have you worked for that wonderful organization?
Since 2004.
And I take it you are in the trial rooms regularly, or are you in the supervising role at this point?
I'm in the trial room regularly.
And over the years, have you gotten to know my client, Judge Scott DeClaudio?
Yes.
And did you get to know him as a lawyer?
Yes.
And have you appeared in his courtroom as a judge?
Yes, I've appeared in the courtroom as an attorney, yes.
Now, as a lawyer, could you briefly describe the type of law Judge DeClaudio practiced and his ability or lack of ability?
Well, he's a criminal attorney in the Criminal Justice Center in Philadelphia. I handled trials, pre-trials in front of His Honor for 5 years.
Could you describe what kind of judge he is, how he acts, his demeanor, his knowledge, how he treats people?
He treats everyone, whether court staff, attorneys, victims, police officers, defendants, with respect. He explains the process to them. It can be intimidating for non-attorneys to be in court, but he explains the process, whether it's sentencing or trial. He's very respectful to people. He's knowledgeable in the law. He's efficient, hardworking.
Okay. Now, you know people in the community who know Judge DeClaudio.
Yes.
Among the people you know Judge DeClaudio, what is his current reputation as a truthful and honest and peaceful, law-abiding person? Is it good or is it bad?
It's good. It's very good.
Now, do you, as a lawyer who's appeared in his courtroom and apparently have known him for many years in the courthouse in Philadelphia, do you have any hesitation in recommending his continuation as a judge of the Court of Common Pleas?
None whatsoever. It would be a loss to the Commonwealth of Pennsylvania if he were not on the bench.
And why do you think it would be a loss?
I've been an attorney for 17 years. I've literally appeared in front of hundreds of judges. In terms of his judicial temperament, his knowledge of the law, the way he treats everyone in the courtroom, he's by far the best run courtroom. There are some new judges that have taken the bench, and they have patterned their style after Judge DeClaudio. These are attorneys that have practiced law for several years. They've appeared in front of other criminal judges, and obviously they know the law, they know what they're doing, but they have practiced for many years, and they have patterned their style, emulated Judge DeClaudio in terms of the way he treats clients, in terms of the way he encourages clients, in terms of the way he does status listings and updates and early termination. I don't know if you could have a better recommendation or idea in terms of how good someone is when you have newer judges that essentially are emulating his style. In terms of when I've had cases in front of him, I've had, obviously, I've had situations where, whether it's me or my client, we didn't get the sentence that we requested. I still have had clients that tell me they felt like they were treated with respect, treated fairly. Multiple family members that told me, despite the fact that we didn't get what we wanted, they felt like their loved one was treated with fairness, with respect, and that he or she got a fair sentence. It's the most efficient courtroom I've ever been in. It's the best judge I've been in front of. It would be a huge loss to the Commonwealth of Pennsylvania if he were not on the bench.
And how many times have you been in his courtroom over the last 5.5 years?
It's been multiple times a week for 5 years on a consistent basis. So literally thousands of times, literally.
Thank you, Mr. McLaurin. Your witness, Ms. Norton.
Thank you. I have no questions for the witness.
Any other questions for Mr. McLaurin? Hearing none, you're excused, counsel. Thank you.
Thank you, Mr. McLaurin.
Thank you. Thank you for allowing me to address the court. Thank you.
And the next person I believe has shown up in the virtual room is retired Judge Chris Wogan.
I see his name, but do not see him.
There he is at the top. Judge Wogan, can you hear us? I don't think you can hear us, Mr. Metz. Judge Wogan, can you hear us? Judge Wogan?
I do see him now.
I think he's muted, Joe, but I don't know if he can hear us. Judge Wogan, if you can hear us, would you unmute yourself?
According to the list, he is not muted.
Judge, can you hear us? Judge Wogan, can you hear me? We can see you, we just can't hear you, and I don't think you can hear us, Judge Wogan.
Doesn't appear that he has audio.
We're texting him right now to ask him to tell him we can't.
Looks like he's reading his text.
So that perhaps he'll be able to resolve it.
Technology in action here.
David's here. Will be next. Well, if we can't get that working, I have Attorney David Glansberg present, and I'll call him and we'll stop immediately if Judge Wogan's audio works. So with your permission, Judge Eisenhower, unless Judge Wogan can hear us now, I'm going to put Mr. Glansberg in the witness seat briefly. Shall I do that, or shall I tell him to wait?
Judge Wogan, if you could try to speak, it does appear that you do have a microphone and it's turned green now.
Judge Wogan says he cannot hear anyone.
Judge Wogan texted us and said he cannot hear anyone.
Oh, all right. Excuse me, Your Honors. It just disconnected the audio.
Thank you.
In the last 10 seconds, so.
It's good to see you, Judge Wogan. You'll have to be sworn in, unfortunately, because that's the modern way, even for a judge.
No problem. Should I take the oath on my own, or does someone administer it to me?
The reporter will. I believe she's there. Can you administer the oath to Judge Wogan?
I'm back now, Mr. Stratton.
Okay.
Reporter, can you please administer the oath to the judge?
Judge Wogan, do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
I swear to, I will tell the truth, so help me God.
Good morning, Judge Wogan. Always a pleasure.
Well, good morning, Mr. Stratton. Good morning, Your Honors.
I first met you when I tried to challenge your election when I was representing Charlie Doherty with the Republican challenger to Mr. Meehan. You remember that in 1980?
I remember it very well. I won by 251 votes, and I realized I will never run against another incumbent after that.
You had the privilege of serving as in the House of Representatives for, was it 20 years?
21 years and 1 month.
And you were a Republican chairman of, what was the Urban Committee? I'm trying to remember.
Initially, I chaired Urban Affairs, and then I moved to chair Consumer Affairs, and was a member of Judiciary during my entire tenure as a state representative.
Then you had the privilege of being elected to the Court of Common Pleas of Philadelphia County.
Yes, I was elected in 2001 and was retained in 2011, and resigned to take another position in August of 2015.
And you currently are a practicing lawyer handling at times some criminal and civil litigation in Philadelphia County? Judge
Yes, I did that, and I did it while I was a state representative as well. So my belief was I didn't want to get rusty, and it would help me have a better idea what I was talking about when I would debate on the House floor if I actually, was going to courtrooms.
And you also served in the military and had the rank of lieutenant colonel, was it, or major?
No, I retired as a lieutenant colonel after 28 years. I was initially a field artillery officer and switched to JAG. If I didn't leave field artillery, I would be wearing hearing aids, I'm sure, for this hearing.
And you, in fact, served with Chief Judicial Counsel, Mr. Long. Am I correct?
I did, as a matter of fact. I don't think I've seen him in probably 25 years, but as I recall, he worked for the Cleveland Browns, I believe, when I knew him, and I heard through the grapevine he outranks me now and went to Iraq, which I
Mr. Stratton,
Mr. Iraq.
Can we get back on point here, please?
I will focus in now. Sorry about that. Do you know Judge Scott DeClaudio?
I do.
How do you know him, Judge?
Well, I know him both, or I should say I knew him during my tenure as a common pleas court judge in Philadelphia. And then since I retired as a judge, I know him as myself as a practicing attorney, and I've actually observed him in his courtroom.
Can you describe to the Court of Judicial Discipline your observations of Judge DeClaudio as he's running his courtroom?
In my opinion, Judge DeClaudio is one of the best. He knows the law, and he treats people with respect. And the times I was in his courtroom and also talking to other folks who perhaps are as familiar with him as I am, understand that he ran an efficient courtroom, disposed of a lot of cases.
And does he treat people, how does he treat the litigants and the defendants and victims in the courtroom per your observations, Judge Wogan?
He treated everybody with the utmost respect. and listen to people, which I think is very important.
Judge Wogan, you've gotten to know people in the legal community who know Judge DeClaudio over the years. Is that right?
That's correct.
Among the people you know who know Judge DeClaudio, and of course who you've spoken to, what is his current reputation as a truthful and honest person and as a peaceful and law-abiding person? Is it good or is it bad?
It's excellent. Excellent. He has a tremendous reputation as a judge, and I would say the same when I was familiar with his work when I was a judge. Equally excellent reputation.
And you, of course, know what's required of lawyers, but you also know what's required of judicial officers due to your 15 or 16 years of service on the Court of Common Pleas of Philadelphia County. Knowing that, knowing Judge DeClaudio and observing him, do you have any hesitation in recommending to the Court of Judicial Discipline that Judge DeClaudio be allowed to continue as a judge on the Court of Common Pleas?
I have no hesitation in that regard at all.
Judge Wogan, thank you. Ms. Norton, your witness.
Judge Wogan, can you hear me?
I can, Ms. Norton.
Thank you. I have a question for you, and you've indicated that he has a reputation as being a law-abiding citizen. Is that correct?
Yes, that would be correct.
And does that reputation, to your knowledge, take into account the fact that he was held in contempt multiple times by the Court of Common Pleas of Montgomery County for failing to follow that court's orders?
Objection, same objections as before for the other witness.
That's overruled.
I was not aware of Judge DeClaudio being held in contempt until this proceeding arose.
But in answer to the question, then, the reputation that you spoke of, that Judge DeClaudio is a law-abiding citizen, does that reputation take into account his failure to abide certain court orders and having been held in contempt?
He ruled.
I am now aware of those orders in which Judge DeClaudio was held in contempt of Montgomery County. I would say that would not change my opinion, and that would not change what I have heard, because I understand that you're asking me if anyone has said anything negative about him, and my answer has not changed. That his reputation, as far as I have heard from court officers and lawyers and other judges in Philadelphia, remains excellent.
I have no further questions.
I have no other questions. Is the court?
Any other questions for Judge Wogan?
I have none.
Hearing none, Your Honor, thank you for coming in. We appreciate it. You're excused.
Good to see you, Judge Wogan. Now, our next witness, I'm sorry, the next witness before I called Judge DeClaudio.
Have we lost the audio?
Do you have me? Can you hear me now?
Excuse Judge Wogan.
Yeah, I want you right here. Can you hear us now, Mr. Judge Eisenhower?
Yes.
I'm going to call David.
I'm not hearing anything.
Could we excuse Judge Wogan? He can't hear us. Mr. Metz, can you remove him to the virtual room?
He's left the call.
Thank
Judge
you.
Wogan has.
I'm going to have David Glansberg sit in my chair. He's our final witness before I call Judge DeClaudio.
Thank you. Good morning, everyone.
You got to speak up so they can hear it.
Good morning, sir.
Court reporter, please swear the witness.
Do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Good morning or good afternoon, Mr. Glansberg. Would you give us your full name and spell your last name for the court reporter?
Yes, David Seth Glansberg, Glanzberg.
And Mr. Glansberg, for how many years have you had the privilege of practicing law in the Commonwealth of Pennsylvania?
33 years.
And you currently are an active practitioner in Philadelphia and the surrounding counties?
I am.
And your practice is primarily emphasizes criminal law, or am I incorrect on that?
No, you are correct. That is a majority of my practice.
Now, you are one of the oldest and longtime friends of Judge DeClaudio. Is that a fair statement?
That is a very fair statement.
And when did you first meet Judge DeClaudio?
I met Judge DeClaudio when we both were in the DA's office. I think that would be 1988. And I left that office in 92, and Scott left shortly after me.
Remember Judge DeClaudio, that's
I'm sorry, Judge DeClaudio.
And did you and he work on cases for a while in the world of private practice?
We have, over the years before he took the bench, we had a number of cases together.
And have you maintained your friendship with him over
his courtroom?
But you have sat in at times and watched him as a judge, am I correct?
I have gone to his courtroom many a time when I'm in the building, which is almost every day before the pandemic. I would go in and just watch if I had some downtime.
Describe to the court briefly, because we've heard a number of practicing lawyers describe his performance, but describe your observations of Judge DeClaudio on the bench over the last several years.
I can honestly say that Scott is one of the fairest judges I've ever seen.
Remember, he's a judge. We don't call by first name.
I'm so sorry. Judge DeClaudio.
You get used to this.
Yeah. Judge DeClaudio is one of the fairest jurists I've ever seen, and I've appeared before many judges over my tenure of practicing law. And the only thing an attorney can really ask for is a fair playing field. When you go in, whether it's federal court or state court or municipal court, all you want is a fair shot. And I can tell you unequivocally that Judge DeClaudio treats everyone in his courtroom fairly, honestly, and equally. And you do get a fair shot in his courtroom. When I've watched him do motions, when I've watched him do trials, fair. And that's all you can ask for somebody.
Now, Mr. Glansberg, let me ask this. You are a personal friend and see him regularly. You are now aware of that lawsuit that brings us here today, where he acted very, very badly and inexcusably. Am I correct?
I am.
And has Judge DeClaudio ever discussed that with you and his conduct in that lawsuit?
Not till after it happened.
At the time when he was undergoing that, he in any way call you or tell you he had that civil lawsuit against the athletic club?
No, I wish he had.
And has he since you're aware of it, what has he said about his inexcusable conduct in that particular case?
Exactly that. It was inexcusable, dumbest thing he's ever done. And all I can tell you, he was under a lot of stress at that time. His marriage, his divorce hit him hard. And he was having a difficult time, his daughter, but he's on track. And I can tell you that when I go into his courtroom, very productive. Even during the pandemic, when I was making fun of other judges not working as much, he was always in that building. And now I know he has taken over another judge's list as well as all the PCRAs in Philadelphia. So I can tell you the Judge DeClaudio works extremely hard. He's excellent at his job. Not good, excellent at his job.
Let me ask you this. I would assume the judges on the Court of Judicial Discipline have some concern about his personal life because of, this case where the athletic club is Exhibit A, so to speak, on that particular matter. Have you observed changes in him recently in his personal life that might suggest that that kind of stupid conduct he exhibited in the athletic suit won't occur again?
Absolutely. Um, it- Personally, Judge DeClaudio has gotten out of a very long-term relationship that I don't think was in his best interest. I think his head for the last 6 months, since that relationship ended, has completely been clear. I think that during that time, that was also a part of this. The person I see today is different than that person in the sense that he has his act together. What he does professionally and personally are in the right direction. And I think it would be a disservice to the citizens of Philadelphia for him to be removed.
Now, Mr. Glassberg, you know people in the community at large and the legal community that know Judge DeClaudio.
I do, many.
And among those people you know who know Judge DeClaudio, what is his current reputation as a truthful and honest person and as a peaceful and law-abiding person? Is it good or is it bad?
It's excellent.
You know him probably better than all of us.
I would think I do.
Do you have any hesitation in recommending to the Court of Judicial Discipline that Judge DeClaudio be allowed to continue in his role as a judicial officer?
I have no hesitation whatsoever.
Ms. Norton, your witness?
No questions, thank you.
Thank you.
Wait, the court may have a question.
Any other questions for Judge Glanzman, Mr. Glanzman?
Landsberg.
Glanzberg, sorry.
No questions.
All right.
I think it might be a good time for a break. I, for one, need to charge my computer. So why don't we reconvene at 1 o'clock? It's about 5 minutes.
I have 5:01 now, so we'll return in 5 minutes?
Yes. Would the court reporter please swear the witness?
Your Honor, would you raise your right hand, please? Do you swear or affirm the testimony you're about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon. Good afternoon, Judge Judge DeClaudio. Having a bad day here. State your full name for the record.
Scott DiClaudio,
And how old are you sit here today?
56 years old.
And what was your training for college and law school? Where did you attend?
Went to Central High School, then Temple University, and then Delaware Law, which became Widener Law, that became Delaware Law.
And when did you graduate from Delaware Law School?
I think 1990.
Out of curiosity, what did you major in college?
Marketing and pre-law, dual major.
When did you have the privilege of being admitted to practice law in the Commonwealth of Pennsylvania?
I believe 1990, but I was a certified intern. Back then, in the DA's office, you were able to apply and try cases prior, and I think I tried cases late 88, maybe 89, before I was a lawyer.
Is that where you met Mr. Glansberg?
It was.
And when did you leave the district attorney's office?
I think 1992.
And after that, where did you practice?
I worked for Mr. Louis Savino, Louis T. Savino and Associates. We did criminal defense work.
That's Savino?
Savino Jr.
How long did you work for Attorney Savino?
Approximately 13 years.
And
I was in the DA's office for 4, Mr. Savino for 13.
And did you do primarily criminal trials?
98%.
And after you left Mr. Savino, where did you go to work?
I opened my own firm.
And how long did that firm exist?
Approximately 10 years.
So you were elected to the Court of Common Pleas?
Yes, sir.
And where was your firm located?
In Center City, Philadelphia. Both Mr. Savino's firm as well as my firm were at 2 Penn Center, 15th and JFK Boulevard.
Now, Judge DeClaudio, how many cases do you estimate, criminal cases, you tried to jury verdict over your years as a practicing lawyer?
At least 100.
How many non-jury cases do you recall trying to jury verdict over the years?
Several thousand.
Now, you as a practicing lawyer were involved in a number of civic activities and community-related activities, am I correct?
Yes, sir.
Would you describe briefly to the Court of Judicial Discipline some of your activities?
When I was an attorney, I was very active in MANNA.
What's MANNA?
It's MANNA. It's a food distribution service, but it's also making of the meals, which I really liked. So on a volunteer basis, me and either friends or family, or eventually when I was a judge, defendants would go. And for shifts of 3 or 4 hours, we would actually prepare the meals. We would chop the onions, put together the fish cakes, and then package them and put them. I'm talking about 1,000 meals a shift.
Where was this located, Judge, that you were doing this?
It was originally where the Salvation Army was. It collapsed, and then it moved in the last 4 or 5 years to about 21st and Spring Garden-ish, near Whole Foods.
And also, as a practicing lawyer, you did a number of court-appointed cases, am I, in Philadelphia County?
I did court appointments early in the career, a lot of pro bono work later, and taught some CLE classes along the way.
And you were, over the years, you have worked with judges, concerned with judges over the years?
No, that's more recently. They reached out as a judge, judges helping judges and judges helping lawyers. I'd never had an issue, but I've certain way of trying to help people, and whether it's stress or drugs and alcohol. I've had, sadly, many friends and family members who've struggled, and I like to think I give good advice. As my friends say, I don't take it as well as I give it, but I enjoy giving back.
Now, before we get into your judicial career, you were involved in a lawsuit with the Kingwood Athletic Club, am I correct?
Yes, sir, the Kingwood Club.
And what was I don't want to spend a lot of time on this, but what was the essence of the lawsuit?
My daughter became a squash player in middle school and high school, championship level. So not only did she do it at school, but we joined a private club. I played with her to advance her athletic career. Eventually she got hurt, actually fractured her spine, stress fracture in her spine. So we stopped going to the Kingwood Club. I got a bill at the end of the year. I did not pay it.
And after the bill came and you didn't pay it, was there litigation by the club in reference to the amount owed?
Yes, they sued me in small claims. District court managers, district court in Montgomery County. I did not appear. They got a judgment of about $1,200 or $1,300. I found out about it and I appealed it to the Court of Common Pleas in Montgomery County.
Now, do you agree that your conduct throughout that lawsuit for a 2 or 3 year time period is, well, how would you describe your conduct in handling that case?
I've thought of a lot of adjectives for the court. I think I'm going to settle on reprehensible, without excuse, not even explanation. It's unfathomable that as a lawyer, as a person, knowing who I am, that I would just ignore it. I could have excuses or explanations or rationales, but none of them make any sense, even in my own head.
At some point, did you finally resolve the case and finally show up before Judge Burton in the Court of Common Pleas in Montgomery County?
Eventually.
And on that day, what was the resolution of the case, if you can advise the Court of Judicial Discipline?
I believe the original debt was about $1,200 or $1,300, $100 a month for 12 months. We haven't gone. That's the genesis of why I didn't want to pay, but that's not an excuse. Eventually, when I failed to appear, I was fined $2,500, I think, on 3 different occasions. As a result, I eventually paid the $9,500, which was the $1,200 or $1,300 plus interest and about $7,500 in attorney fees, I believe, so along those lines.
Why didn't you seek legal representation? You have many, many friends who are lawyers when this lawsuit was occurring.
I couldn't give you a good answer. I couldn't even give you a bad answer. There's part, I was not in a good place mentally going through a divorce. Any explanation I would give you to that question would not be satisfactory to any of the 7 judges, nor to myself or my friends or my family or the people I embarrassed by putting myself in this position. There's no answer to that question. I can give you a theory as I sat the last year saying, Scott, what the hell did you do? Like, what were you thinking? But there's no real reason other than I ignored it because I didn't think I owed it. And the collection lawyers would send things this thick and I was busy and I kept throwing them in the trash saying, leave me alone. I don't know how a judge or a lawyer or a human being or an adult could do that, but I did it. So I can't have an explanation. There is none.
Do you have an apology to the Singwood Athletic Club for your bad conduct during that civil litigation?
There's so many apologies I owe, starting with them, obviously, and to the lawyers who I disrespected, especially to the judge who I extremely disrespected.
Judge Burton,
Judge Burton. I mean, I run my room in a certain way, and I give respect and I expect respect. So for me to do what I did is, again, what word did I use? Irresponsible, unfathomable. I mean, we can just get out a synonym of all those words, and I mean them all.
Let me ask you this. How does the court know that you get some other personal problem, maybe other stressors in your personal life, where you're going to go out and act totally irresponsible, particularly as a judicial officer?
That's a good question. I mean, you never know what's going to happen in the future, but this is a lesson learned. This is 30 pounds lost, a lot of sleep lost, a lot of embarrassment caused. My daughter, who's beautiful and kind and smart, has to read about her dad on the front page. For some reason, everything I do kind of gets front page for lots of other reasons. So it's an embarrassment to my family, to myself, to my colleagues, to all the people I try to do well for, all the people I go to man. Everybody who's associated with me has I hope to have a certain idea of the kind of person I am. And for me to embarrass them in this way is probably the biggest punishment I can receive, other than potentially what your honors can do.
Now, you heard you received a public censure from the Pennsylvania Supreme Court for conduct as a lawyer, and you actually appeared in open court at the beginning of the court's argument section, I believe in November or December of 2015, right before you were sworn in as a judge. Am I right?
I don't believe you're right, and I believe Ms. Norton and Mr. Goldstein were also inaccurate. I believe that was March of 2016, after I'd already been elected. I remember it vividly. I remember the whole incident that led up to it, and I remember the comment that I made or whereabouts in talking to Max Mitchell from the legal intelligencer, who was sitting next to me.
Let me ask you this. Did you accepted the censure, and did you except what the Chief Justice read to you from the bench?
That's a very complex question, Mr. Stratton, and there's no humble way to answer it. I would like to explain to the court what that case was about and then eventually what I said. But it was completely taken out of context and time frame wise. I was already a judge. I was doing 140 cases. I was already 3 months in. The judge had told me, establish your reputation, do what you have to do. And I didn't take the day off. I was going to court. And what I told Mr. Mitchell is, if you want to go watch me after reporting on this, I'm going to court right now. I'm going to be a judge. I walked out of City Hall right across the street, put on my robe, and had 40 lawyers waiting for me in 100 cases. So that was the reference. There was no smiling. It was depressing to have Justice Todd yell at me in front of 200 lawyers, having already been seated as a judge. But I would like, Mr. Stratton, I know you probably don't want me to get into it, what that case was about, because I think that might give this court a little better background on what that case was about.
That case was a public censure because you did not withdraw an appeal, even though you had an agreement with your client that not to pursue the appeal to the Superior Court. Am I right?
Correct. And if I can just explain that.
Well, let me ask it this way, because I want to cut you right to the chase. Your client did not file a complaint with the court, with the disciplinary board, did the client?
Mr. Stratton, I'm going to have to explain it, and I'm sorry.
Go ahead.
So I represented Mr. Ahmed Khalil in a shooting case in Philadelphia. The case wound up he got found guilty of a gun charge. He wanted, while on supervision, to go to Libya and Egypt. The probation officer didn't let him. He hired me to go to the judge. I went to the judge and the judge said, no way can you go to Libya and Egypt or else. He went to Libya, got arrested at the airport. At his VOP, which I represented, he got 1.5 to 3 years. He wanted to appeal it. I filed notice of appeal. In no way could he ever win. His wife didn't want to pay. After I filed notice of appeal, they decided they didn't want to proceed. I eventually got letters from the chief of appeals from the DA's office, chief of appeals from the DA's office, the client and his wife, who all said that you didn't have to withdraw the appeal. It's a may, not a shall. And the appeal died its natural course. Again, the defendant, his wife, as well as the DA's office, PD's office, said I had no other obligation. Another lawyer who had an axe to grind, I'll just leave it that way. I was trying to get this RFP, the second public defender's office, revamp the way court appointments were done in Philadelphia. Got the contract from the city, 50 lawyers. We were going to do great things. And the lawyers who were going to be out of business wanted me to not proceed with that. It went to city council. The mayor actually signed the contract. One of the lawyers 2 years after that, after the defendant was already out of prison, filed that complaint against me. I was going to be a judge and just bad judgment. I thought, okay, I'm going to be a judge. I'm already elected. Do I really need to fight this? Do I need to pay the money? But disciplinary counsel then, Mr. Harry Brummer, had the affidavits from my client, his wife, and it was obstruction of the administration of justice for not withdrawing an appeal.
Right,
and that's pretty much it. So that was the discipline, and I was concerned about it, but I was a judge, and disciplinary counsel at that time and I had kind of an agreement. So that's basically the explanation.
Now, since that time, let's describe the courtrooms you served as a judicial officer. Where were you placed after you went to baby judge school and became a judicial officer?
Judge Meinhardt, one of my peers and mentors and one of the people I respect, asked me to play a specific role. In Philadelphia County, we have what's called smart rooms. As you heard Ms. McLaurin say earlier, all felony criminal cases from different sections of the city go into a certain room for pretrials, motions to quash, guilty pleas, motions to suppress, and if I can't resolve them, then I would send them out to my colleagues for jury trials or waiver trials. So the goal of the program is to try to be fair to all sides so you can resolve cases. And in Philadelphia, when we have tens of thousands, and when I started, Judge Kane had East Division, Judge Palumbo had Northwest, and Judge Palumbo, it was Palumbo, Kane, and Erdos. One had East, one had Northwest, one had Central, and Judge Means had IP. And Judge Meinhardt asked me if I can do all four.
Tell them what IP is. Not everyone knows on the court.
intermediate punishment for drug treatment. It's another program that's pretty voluminous in Philadelphia.
Right.
And Judge Meinhardt's asked me if I can do all four. And of course, I accepted that challenge.
Judge Meinhardt was then the supervising judge for criminal cases in Philadelphia County.
Correct. He was supervising criminal judge.
All right. So Judge Meinhardt gave you that job described, and you were in room 905?
905. So one day I would do East Division and have 120 cases. Next day, Northwest. The next day, Center City. Next day, IP. And then on the fifth day, I did waiver trials and motions because I didn't want to stay unbusy.
And you handled a number of cases to resolution, am I correct?
Each day we'd have between, and this is a number that most people won't believe, but Judge McCaffrey probably will remember, between 100 and 150 cases a day. And I would resolve 10 a day on average. I mean, I don't mean like just continue, I mean resolve.
I'm handing you what has been marked, some exhibits P53, you can turn to that, and P54, which are productivity summaries during your tenure as a common pleas judge. Do those documents accurately reflect the number of cases you resolved, P53 and P54?
They knew Mr. Stratton, but
I say P, I'm sorry, R53 and R54, forgive me.
They do, but I'm not as proud as the amount of cases that I resolved. This is the way I resolved them. Taking the time with every single person. I'm sorry, Mr. Stratton.
We're going to get to that in a second. After, more recently, you left now 905, and you've been assigned to 1001 and also Judge Meinert's old room 701, am I correct?
702.
702. Tell us what have you done for the last 6 or 8 months since you've been moved from 905?
Well, immediately after 905, we had the pandemic, and I was one of the 3 judges who were asked or tasked to do all the written submissions. So we shut down the Criminal Justice Center from like March to June, but there were still people in custody. People had to be paroled, people who were waiting for drug treatment, people who wanted bail reductions. So I was one of 3 judges tasked with reviewing 10 to 15 written submissions a day, 7 days a week. And I did that for about 2.5 months and doing orders. After we came back from the pandemic, and I think I was one of the first ones back, like June 1st, I've been in my courtroom almost every day, live. And I now run a majors room.
So what's a majors room for the judges who aren't from Philadelphia?
Majors rooms are the more serious felony cases. The 3 or 4 juries I've done since in the last couple of months were home invasion, robberies, shootings. I mean, the most serious of the cases. But I still have my docket of the 6,000 or 7,000 people on my supervision from the times I ran my smart room. And I've taken over pretty much Judge Meinhardt's room. He retired about a month ago. So I've done his room for the last 3 weeks as well as mine. I go up and down, do my list, do his, come back, and then wind up doing cases at the end of the day.
Now, tell us your philosophy on judging in the Court of Common Pleas and how you treat litigants and people with that kind of massive volume.
I've been in front of a lot of judges. I've tried cases in 17 different states. I've been, I guess, in front of hundreds of judges, some of them which are better than others, some of which I respect way more than others. And I tried to take little pieces from each of them to be the best jurist I can. And that might sound like a cliche, but I mean it. From judges who used to make you not be able to leave their room, even though you might be the first, last case on the list, and literally fold your hands on your lap and you couldn't leave to go to other rooms. And, scream at you if you're 10 minutes late when there was a, 10-car pileup. I decided I wasn't going to be that judge. I was going to be reasonable. I was going to be sensible. I was going to be a person. And I was going to be a person because I was a prosecutor, defense attorney, now a judge, who listened to victims, who listened to police officers, who listened to defendants, who listened to families. And one of my first days, Your Honors, I remember it like it was yesterday. It was 4 o'clock. We did 120 cases. I had one defendant who had to be brought up, and we were dog tired. And I said to myself, how can I not give this young man the same speech or give him the same time that I gave other people at 10 o'clock or 12 o'clock? And I prided myself on my daughter's life, taking my time on every case, reading every piece of information, listening to every single person before I decide what is fair and just. And I promise you that. I may have made errors outside my courtroom, but I have not made one that I can remember inside.
And now you've been recently, in the last month or two, assigned most of the PCRA petitions in the Court of Common Pleas of Philadelphia County. Am I right?
Actually, it started in January, so
Explain what that is first, in case some judges don't do criminal work.
post-conviction relief. It's the cases you hear about DNA evidence or new evidence or new witnesses or recantations. The cases you read in the newspaper that someone gets out 31 years later because prosecutorial misconduct or witnesses recants.
Or ineffective assistance.
Ineffective assistance. I mean, post-conviction relief runs the gamut. And we had judges who weren't as efficient, I think. So I was also tasked with running the PCRA to quote unquote, there's no nice way to say it, to kind of move it along and make it more efficient and be more productive. So
How
I
many
got,
cases have you moved, Judge, since you've taken?
I'm trying to be humble, Sam. I originally got 297 cases. I have 8 or 9 law clerks at this point. I resolve about 10 a week. Prior judges, about 1. Judge Meinhardt left. I took all his PCRAs, and then there's another judge that was left with 100, and the present judge just took those away and gave them to me. So I currently have 497 PCRAs that I'm reviewing at different stages. Beside my juries or trials and BOPs, I'm also running the PCRA program, and I think I'm the only judge doing it. Some might have like 5 or 10, but I have 497.
So, Judge, your normal court day then would be, when did you start in the courtroom and when do you leave?
I start at 9 a.m. promptly. I haven't been late in 6 years. And I leave. I mean, I just got a call from my president judge, do I live there? Because literally there's a room where I live there. It's like not a joke. I got a call on a Sunday. There's rooms you live there. I'm like, yeah, when I leave at 9 o'clock at night or 11 at night, I like working. My daughter's moving to New York. I'm single and I love my job. So I work 12-hour days every day.
Okay. Now, let's talk about your civic and community activities as a judicial officer, and particularly your involvement with your defendants on probation and parole. Describe some of your activities. I assume you're still doing MANA, because you mentioned that. Am I correct?
Yes, I'm doing MANA on steroids. I've come to adjust. I'm one of my public defenders on smaller violations that the thought process is judges put everybody in jail for smoking marijuana or missing an appointment. That's not true. If you have small violations and repeated, I'll send you to supervision at community service. And it's not always the best organized. So I decided, because I go to MANA, that I would bring defendants, I would order people to go to MANA. And I know how organized they are, and they sign in computer, and I decided that I would start going with them. And I bring a public defender, a DA, head of probation, a criminal defense lawyer, and 30 defendants every month. I don't know if you've seen the pictures. I think we submitted them. Every month I bring 30 defendants. We address their problems. We work hard. We make 1,000. Our goal is 1,000 meals every time we go. And we've won every month. Other than the pandemic, I don't think I missed a month for years.
In the exhibits that we filed in the second set, we have exhibits R55, which is an article about the community service. What is that? It's R55, Judge.
Okay, I'm sorry, sir. I got it.
Now keep going. Start with it.
Yes.
A couple pages. What is R55?
There was a reporter in the room. There have been several. I think there was a documentary recently. I do so many cases, not because I'm anything special. It's just where I was assigned. We have a lot of high-profile cases. A lot of high-profile cases. So there will be reporters there often. And while they're waiting, they might have heard me. So 2 or 3 documentary crews or reporters have heard me say that and thought it was an interesting story. So there's been some documentation of that community service.
Is that what that article R55 talks about, you serving with some of your probationers at MANA meals?
Correct.
Now, R56 is a letter from Stop the Violence of May 5th, 2021. What is that, Judge?
So one of the other things I like to do in meeting with people, and they watch, I'm being honest, how much I care. I'm like, why can't you be more proactive? I'm like, well, I can't be proactive. I'm reactive. You've already committed a crime. You're already pleading guilty. I'm already sentencing you. There's not a whole lot I can do after you're already in my courtroom. So a way to be proactive was I meet with youth groups, such as Stop the Violence, or go to high schools with juvenile lifers and lawyers and people in the community and talk to juveniles from 9th to 12th grades, whole auditoriums, Autumn Reed, Strawberry Mansion. So if I take a Chambers day, which I don't take many of them, I'll go to try to be proactive and stop the violence. is one of the groups that come in from Minneapolis. It's also a gum program that I have that kind of goes hand in hand with meeting with juveniles and going to high schools. And a juvenile lifer is someone who was sentenced to life as a juvenile for murder, but when the law changed, resentencings happened. So some of those young men spent 30, 40 years in prison. So I thought they would get that message across a little better than me to inner city high schools. So I partnered with 3 or 4 men who spent 30, 40 years in prison, and they come with me to speak to these juveniles about the pitfalls of hanging around the wrong group, driving a car when somebody else is doing something, trying to fit in. So Stop the Violence and that program are kind of hand in hand.
And R57, I don't know why I want to say P. R57 is a number of photographs that I included. What are those photographs?
That's a third program that I have, or fourth. So I have a unique way of doing things, Your Honors. I think I'm up to 1,249 young men for carrying guns in Philadelphia. I like to give people an opportunity. And what you'll see in everyone's hand are laminated sheets of names and addresses from Stop the Violence. And the idea is I give a pretty long speech of, you made a mistake once, but if you carry a gun a second time, I'm going to assume you're going to do something bad with it. And I write on my file the sentence I'm going to give them if they come back. It's a pretty long speech about how young men don't know how to de-escalate situations. I won't bore you with the speech, but it's about 15 minutes. Have them sign my file what the future punishment would be, which involves state prison. And there's 1,249 names on these lists. Judge McCaffrey won't believe the number, but only 5 people have recidivized with a second gun in the last 4 years. 5 out of 1,200 so far. And I've gone about 14 months without having somebody come back. So that's another thing that I'm very proud of.
And now in your trial room, are you still able to continue some of these programs with probationers and parolees who are under your supervision?
Every day. As a matter of fact, I was proud of another thing I do, the early terminations of supervisions. Mr. Krasner is an advocate of early termination or less supervision, but I actually did a case yesterday.
Mr. Krasner's the DA?
The DA of Philadelphia County.
Okay.
And Mr. Jamie Funt had a petition in front of me. It was just comical because I've been saying this. I've been promising people since I started, I might give you 3 years probation, but give me 2 perfect years. Or it's a testimony from a hearing I did 4 years ago, pre Mr. Krasner, where I made this promise. I'm giving you 4 years probation, give me 3 years, do 50 hours community service, come to Manna. And he gave me the notes of testimony. It was one of the coolest things ever. And I terminated him early yesterday. But it was a program that I had initiated well before it was popular.
Mr. Funt sent a letter, which I marked as Exhibit B, am I correct, Judge, to our sanctions brief to the Court of Judicial Discipline?
Yes, that was on a different matter of an elderly, mentally ill gentleman that he had represented, that I, not that I go out of my way for everybody, but that I took extra special attention because of his special needs.
Now, you and I have talked about concerns about you're getting too close to your probationers. How do you handle that, Judge?
It's not too close. I'm more like this is what you have to do. There's not really, it's black and white. Don't get arrested for guns or I'm going to put you in jail. Make good strides and good things will happen. Make good decisions. It's not ex-President Trump, President Biden, me, the police, David Glansberg. It's just you. Make good decisions and good things will happen. And I don't think I've been appealed more than a dozen times out of 10,000 because as you heard some of the people who testify, I explain what I'm doing, how I got there, what I'm about to do, and what's going to happen in the future. So I don't really feel I'm getting too close because I'm explaining. They literally signed my file on 40%, 30% of the cases. This is what will happen if you get convicted of another crime. And they just come in and say, Judge, I'm sorry. You told me it was going to happen. I have to accept my punishment. So I know that you brought that concern to me, but I've over 10,000 cases or 100,000 cases that I've had in front of me. I haven't had that issue arise once in 6 years. But I'll be on the lookout for it, Mr. Stratton, I promise, if I'm fortunate enough to still be a judge.
Now, Judge, you did have a prior letter of counsel from the Judicial Conduct Board in March 7, 2019, which is attached as Exhibit A to our sanctions brief. Am I correct?
Yes, sir.
I put that in front of you. What happened there?
Part of me trying to be the everyman and the reasonable person that carried over to my staff. I made, on especially busy days, I would cook and make food. So I thought camaraderie was important. I'd have lunch with my staff, and I had a disagreement with one of my clerks about how something should be in the system. And I don't think she appreciated me calling her boss, and she filed a complaint about me being too friendly or nothing, inappropriate conduct, for which I got a letter of counsel. I took the class that Ms. Norton asked me to take, and I have not had that issue, not even once since.
In fact, has one of those persons asked to be reassigned to your courtroom?
Matter of fact, they have. I have text to prove it, like, oh, can I come back and be like, yeah, not a great idea. And I have dozens of texts from my staff members.
What did you learn from that letter of counsel in terms of how to deal with your staff, who are excellent?
Yeah, I had to remove myself. It's one of the things I continue to work on is I'm an extrovert, and I have a pretty outgoing personality that I had to rein that in as a judge. I can't be friendly to everybody. I still will go talk to people, but I don't sit and have lunch in my jury room with them anymore. And I don't ask them about their personal lives anymore. And I learned to be more judicial, so to speak, which I didn't realize that how that can come across. For the first couple of years, there was no problem until I had an incident, and then I realized I had to change my behavior.
Now, Judge, there was some concern expressed by Judge Eisenhower during one of our pre-hearing conferences, and others, that the delay that you showed in the athletic suit also was the way you acted when you were unrepresented before the Court of Judicial Discipline. Are you familiar with the allegations?
Yes, I remember Judge Eisenhower saying at the pretrial conference, which I took notes, and I know that Ms. Norton has made it a point to bring that to the court's attention.
Now, during that time period, particularly in late 2019 and early 2020, March, April, May, what was going on with the court system and also with the Court of Judicial Discipline? Were things open or were they closed?
Well, first, let me apologize to all the judges, and especially Ms. Norton. There was never any intent to intentionally delay, and perception is reality. And I'm sorry that I gave you the perception that I didn't take this seriously.
And Judge,
but if I can give you a time frame.
One second. When did you and I discuss last night that we were unfair to Ms. Norton in my reply brief that, in fact, she did respond to you when times were, and she did not ignore you? Is that a
No, Ms. Norton never ignored me. No, never by any stretch. Ms. Norton never ignored me. But she thinks that I may not have been as diligent as necessary. And, I would like to remind her, and maybe in way of apology, explain. In late December, Ms. Norton advised me of the complaint. She sent one of her detectives, I don't know if that's the right term or not, investigator to serve me with the complaint. I made sure I was available the first time he needed to. He came into my courtroom, but his computer didn't work. I remember getting off the bench, having my staff, my law clerks, and my secretary help him for about an hour and a half, actually print the complaint to serve me with. And he thanked me 100 times, and I think Ms. Norton was appreciative.
Yeah.
That was in late December.
Was some of the delay, though, getting counsel?
I would like to just give them a timeline if I could, Mr. Stanton. I remember it like it was yesterday. That was late December, almost like December 31st. I went on vacation, as I do over Christmas holiday, January. I came back like January 21st, and I immediately emailed Ms. Norton, and I have the emails. I just got back from vacation. I'll call you tomorrow, and there was a 2 or 3 day period where either I called or emailed, and we emailed up and back, and that's going to the middle of, end of January. And then I had asked for a 30-day extension to see where I stood, which brought me to the end of February. On March 3rd or thereabout, coronavirus was really starting to kick in, March 3rd, and I have my
Judge,
email.
I've had you emails R59 through R63.
Yeah, this is a little past where I'm going, Sam. I got it, I promise. So in about March 3rd or 4th, my girlfriend at the time had been in contact directly with someone who had coronavirus. I sent an email to, I think, several people saying, I'm now quarantined. And this is like March 3rd or 6th. I'm quarantined. I remember calling Judge Tucker, and I remember the
Judge
time.
Tucker was the supervising judge.
He was my supervising judge. Time frame, I'll never forget it, because it was like 5 days after I was in quarantine. And I said, "You want me to come in?" Because my girlfriend came in contact with someone, and it was CDC rules, like I was 2 away. And he says, "Precaution, don't come in." So on about March 3rd, and I have the email, if you want to find that for me, Sam, that would be helpful, which I said that I'm quarantined for Corona in early March. Like within a week of that, the whole I wasn't out of quarantine yet, and the court system shut down, like about March 12th or so. I have it on my phone if you want me to read the email to the court. But it's, "I'm quarantined. My girlfriend came. I'm sorry. I'm not going to be able to do anything." And a week later, I mean, the most unique thing happened in our lives, right? The Corona shut down the world, and our court system was shut down. And yeah, I don't know how much work I did. I know there's some emails in April. I know I met with Mr. Summers, trying to retain him at least once or twice. Going to see him in April during the height of Corona was not an easy interview to have. We tried to reach an agreement. Mr. Summers, I think, sent an email to counsel saying, "I'm trying to get an engagement letter," but his secretary wasn't working. So
Judge DeClaudio, I don't mean to cut you off, but I think we've heard enough about your emails and coronavirus and your girlfriend. I think we should stick to the facts at hand without kind of going too far afield.
Yes, Judge. So bottom line is, courtrooms were closed. I wasn't intentionally being disrespectful to the court. Between March and June, there wasn't a whole lot to do. I called the Office of Judicial Counsel. It was like an answering service.
And Judge DeClaudio, since you retained me, we've moved the case forward as best we can.
I think you file things ahead of time, Mr. Stratton, to my dismay.
All right. Now, let's just go back a little bit. One of the concerns, of course, is what happened on the case with the athletic club in this matter. How can we assure the Court of Judicial Discipline you're never going to allow some personal issue to overcome your good judgment and act badly again as you did with the athletic club lawsuit?
It's a great question. There's no way to really answer it in a vacuum or in the future, but I can tell you this. I have sincerely dedicated my life, given up my law practice and the ticket business I used to own. I gave up a lot to do what I'm doing. And it might seem self-serving, but I love my job. I love the responsibility of it. Defendants, families. I realize that every case I do doesn't affect one person, it affects a dozen. The victims, their families, the defendants, their families, the city at large. So the best assurance I can give you is the dedication and love I have for my job will prevent me from doing anything foolish in the future.
And do you recognize how, when a judge gets held in contempt and sanctioned, doesn't appear in a court, even though it's not your courtroom, how that affects the public's perception, not only of you as a judicial officer, but all your colleagues who are judicial officers?
I didn't at the time, I do now. At that time, I thought it was a civil case in my personal life in the fifth floor of Montgomery County with 8 people there. I did not understand the ramifications and the embarrassment I caused to so many good people.
But do you fully understand that now?
That's what I just said, Mr. Stratton.
You did. So, what's your plea to the Court of Judicial Discipline? What are you asking them to do in view of your bad conduct? It brings us here, but also the wonderful things you have done that we've also discussed. What is your request?
I'm hoping they don't take that an isolated incident as a reflection of who I am as a person, and have heard the people who testified, read the letters, and looked at my background that I did well before I knew I had this hearing. These are things I've been doing for 5, 10, 20 years. So I'm the person I hope that I've just espoused, not the person that made that horrific mistake. And I hope they see the difference.
Thank you, Judge DeClaudio. Ms. Norton, your witness.
Thank you, Attorney Stratton. One moment, please. Judge DeClaudio, I just have a few questions to, in an effort to try and understand what your testimony was. On the issue of the Kenwood Club lawsuit, your testimony today is that you just ignored it. Is that correct?
No, ma'am.
Well, that's what you said earlier. You said, I just ignored it.
I obviously talked to Britt and Henry about 20 times. I was just basically trying to accept responsibility and saying I made a grievous mistake. But no, I didn't ignore it. I spoke to Britt and Henry 20 or 30 times on the phone. I tried to resolve it at one point. We reached negotiations. She had to go to the Kenwood Club and get approval from their board. I negotiated a settlement, and they didn't call me for a couple of years. I thought they just dropped it. I mean, I responded telephonically. I didn't go to court. When I got some of the submissions, I obviously didn't go to court and didn't fulfill my responsibilities as a person, as an attorney, or a judge. So it was a blanket statement that I ignored it, but if you want detail, I can give it to you in a day-by-day or week-by-week basis if you wish to hear.
My next question is, when you were talking about the whether or not you were at work during the pandemic, is it your testimony today, in fact, what I heard you say is that you returned to work in June of 2020 after the pandemic shutdown? Is that correct?
I can't give you an exact date. So between March and June, we were doing a lot of things by written submission, and I was in charge. I was one of the 3 judges who did almost all of those. I couldn't give you the date, but I pretty much went, as soon as they allowed us back in the CJC, I went the very first day, and I didn't miss a day until like December. I think I was in court every single day. They were letting us bring down 10 people a day in the whole building, and I was bringing down 4, doing sentencings and pleas, VOPs, getting people drug treatment, because there were still thousands of people in jail, and I took it upon myself to try to resolve as many of those as possible so they didn't just languish without a hearing. So yes, I in about June 1st until today, I've pretty much been in court every single day.
But prior to June 1st, it's your testimony today that you were not in the CJC, that you were not on the bench.
I'm pretty sure the building shut down like from March to May. I mean, I would have to look at the dates, but the building, we weren't doing, I would have to look at the dates, Ms. Norton. I know I worked pretty much every day, and I know the building was closed for a period of time because of the pandemic. I don't know the exact dates going back a year and a half. I can research it if you wish.
No, thank you. While you, there was a period of time where you were working from home, is that what you're saying?
Absolutely. So I would get emails every day from March. Yeah, I know I wasn't in court. So from like April to June, give or take, the court system was at a standstill, but we had an overwhelming problem of young men and women in prison without having any hearings, bail reductions, paroles, drug treatment, you name it, nothing could happen. There's no judge sitting. So my bosses thought it prudent to do just written submissions. Matter of fact, they wouldn't even permit oral argument even on the phone or Zoom in the original part of the pandemic. And that's why I take some issue with what was I supposed to do. We couldn't figure out criminal court whether we were going to do, there was no Zoom in March, April, and June. Like there was no Zoom. We didn't start that for several months.
Judge, I hate to cut you off. We've all lived through the pandemic. We all understand the limitations. Ms. Norton, could you kind of get us back in focus here, what you're trying to get at here with these questions?
I'll attempt to do that, Your Honor. Thank you. My next question to you is, you spoke briefly to this court today about your private discipline from the Judicial Conduct Board. That's the letter of counsel that you received. Do you recall testifying about that?
I do, ma'am.
And is it your testimony today that the misconduct involved in that matter was, I believe as you said, it was about getting involved in the personal lives of your staff? Is that correct?
Well, my conduct, getting too friendly, saying things that I shouldn't say because of I thought I was closer to them than I thought. So I was treating them like friends, not like employees or staff. That's my, and I said things that I think you thought were inappropriate. I don't remember specifically, but there were a number of allegations, and I think only a few of them were, I can read it for you, but my recollection was I acted inappropriately through my words or conduct, and I changed that behavior based on your letter of counsel.
So it wasn't a matter of just being too friendly with your staff, was it, Your Honor?
Well, it wasn't like, no, you're allowed to take your staff. It was, I thought they were my friends and didn't treat them like staff and may have made inappropriate jokes. I think one of them was I gave one of my staff a nickname, which I thought she liked from all the text, and you can't give your staff nicknames. That was one of the things that stick out. And I haven't given anybody a nickname since.
I have no further questions.
Any members of the court have any questions for Judge DeClaudio?
I have no questions.
Judge, I have a few questions. You've quite an experienced attorney and judge. What is your attitude toward attorneys or parties who fail to appear in your courtroom?
Do I have to answer that?
Say, come back again, I'll see you later, and no hard feelings. I bet you don't strike me as that kind of a judge.
Can I not answer that, Your Honor?
Please answer it.
Yes, I'll answer it. You've heard I treat everybody fairly, and I treat everybody with respect, and they treat me with respect. And it's one of my things with defendants who are unruly, like, listen to me, I'm going to treat you with respect. I'm going to call you sir. I'm a judge. You're going to call me sir. And that's kind of my thing, which is almost ironic, isn't it, Your Honor, that I demand respect, and they give it to me, and I give them respect back. So it is, so I have the Abdul Rahman Silver rule, 2 lawyers that you probably have letters from. I mark cases must be tried, and I don't try to hold the Commonwealth as being the only one ready. 2 attorneys in 6 years didn't appear, and I drugged them back from Chester County and federal court to be there that day. 1 attorney did not appear because he went to California, and I'm talking about in 6 years, Judge. I'm talking about 10,000 lawyer appearances. He went to Manna for 50 hours. No,
So you don't take it lightly. You don't take it lightly when attorney parties were to fail to appear in your courtroom for a scheduled hearing.
No, sir.
Um,
Which is ridiculous that I wouldn't show up and I demand that respect. Yeah, that's quite the quandary, sir.
One of the things we haven't talked about today were, of course, some of the violations in this case, in my view, serious. Your failure to comply with the state ethics laws and report fairly substantial federal tax liens. These were not negligible amounts of money, things that seemingly would slip your mind. It did take quite a while for you to finally comply and report those. I want to give you an opportunity to address that because those are things that are relevant, at least to me in this case.
That's a little bit easier for me, Judge. One, I have to take issue, and I try not to take issue with when a judge asks me a question, but when Ms. Norton brought it to my attention, I fixed it within 24 hours. The next day, I amended my complaint, one day. So I think that you might have inaccurate information. It was the next morning. 2, while it might have been a significant amount of money, I'm not sure if you're aware, we don't have to write the amount on the financial statement. It's just who you owe money to. So it wasn't like I was embarrassed by the amount. You just have to write who you owe money to and what the interest rate is. And 2 other things. I promise you, it wasn't intentional. It was an oversight. I read it and I reread it. And it wasn't meant to deceive. Matter of fact, over the course of my IRS issues, of which should be getting resolved, the AOPC, who sends me my check, had 3 different occasions. Once they took my whole check. Twice they took $1,000 out. So the AOPC very well knew that I owed the IRS money, so they'd be forced to hide it from the court system when they're taking money out of my check, and there'd be no reason for me to hide it. I wasn't embarrassed. I mean, I may have been embarrassed if I had to write the number 200,000, but you're not even required to write the amount.
Well, the purpose of the filing is for the public to review it. Isn't that right, Judge?
It is. They would have known I owed the IRS money, but I actually read it, Judge. I just misinterpreted it, and you can believe me or not. It's who are your creditors and what's the interest rate? There wasn't an interest rate.
I filled them out. I understand them, yes.
So I just didn't understand the instruction. I wasn't trying to hide it. And not that I'm Monday quarterbacking here, but I thought most of that was so people would know of any perceived biases or prejudice. The IRS doesn't appear in my courtroom ever. Not that that's an excuse, but I really did think about it. I just didn't write them down. And one of the things you heard me earlier, Judge, is talk about I had to give up some things like my practice and ticket business. When I gave up I made a lot of money when the Phillies won the World Series in like 2008. When I became a judge, I had to sell all my assets at about 30% of what they were worth. So the losses that I've had since dwarf and will be reflected in the future that I won't owe tax money. I mean, literally, I sold jet seat licenses for pennies on the dollar that I had accumulated over a decade. So I should have written it. That was more of a mistake. And you heard me take full responsibility, I hope, and I hope you heard it in my voice. That one, I assure you, Your Honor, was not intentional in any way. There was no reason to deceive anybody. Nobody really reads them, and there was nothing I was trying to hide. So I'm sorry for doing it, and I'll never do it again. And when I filled them out this year, I sat down and then went back the next day. Is there anybody I'm forgetting? There's a credit card I didn't write. But once I was alerted that was it, I filled it. I amended it the next day, Your Honor, I promise. And it wasn't intentional. I don't know if you can hear it in my voice or not, but I promise you there was no thought or malicious intent. That I swear.
I have nothing further. President Judge Jones has a question.
Yes, ma'am. Hello. I can hear you.
Hey, there we are. Okay, just a really simple ask. We're all professionals and we have to learn how to balance work and life, and we can't get busy and kind of let things slip through the crack. Do you have a game plan going forward on how you're gonna balance? I mean, we go through issues and divorces and deaths and all kinds of things, but we still have to balance what we do. And it just seems like you had a little difficulty with some good reason, but you got to make a conscious effort to balance what you're doing with your home life. So you have a plan for that?
Your Honor, you couldn't be more correct, and we all should strive for that balance, right? But the debt and the divorce were about 6 or 7 years ago, Your Honor. And I'm in a really good place, and I love my work, and I have balance, and I work out, and I love community service, and I love my job, and I have friends, and I play tennis on Saturdays. So I have a really good balance, Your Honor. I thank you for bringing that to my attention. I'm just a single man whose daughter's moving to New York, and I love my job, so I probably have a little bit more work, but I love it. So it's almost like a hobby, but I have hobbies and friends and sports. So I appreciate that concern, but I'm in a good place, and I have been for a while. But I hope that answers your question, Your Honor. No. And you'll see through the letters, I read through them. I mean, I'm a good person, I promise.
Any other questions for Judge DeClaudio?
Yes, I have a question, Judge Baranowski. I understand that you were found in contempt for that civil suit in Montgomery County. I mean, contempt is basically being disobedient or disrespectful to the court. And you are a judge. How do you equate that?
Your Honor, I wish I had an answer for that question. That was almost like, do you still beat your wife? No matter what you answer, you can't win. There is no answer for that. There's no appropriate response other than, I'm deeply sorry, it will never happen again. And I can't even offer you an explanation. I can offer you a theory as I've sat around the last year and not sleeping on why I did it, but that would not answer any of your questions, nor would it be an appropriate response. But I have some theories in my own personal life why I did it, but none of them are adequate, not to myself and certainly not to Your Honor. If you want me to try to explain it further, sir, I will.
I think Judge Foradora is trying to ask a question, but he's on mute.
Judge Foradora, you're still muted.
Can you hear me now?
Yes.
You can.
Okay. I wanted to follow up on Judge Baranowski's question, because everyone who's a judge on this video knows you have a personal life and a private life, and we have to conduct ourselves with the decorum of the court. Now, in the situation with this club, they filed suit, so they have a record of what you do. I want you to reflect, if it wasn't that type of club, or they didn't have an attorney who would do it, or they didn't want to pay it, they might be out there saying, Judge DeClaudio just said, I'm a judge, don't pay the bill, I'm not paying the bill, which is what that kind of appears like you did, to take your personal life and say, hey, I'm a judge. Now, you've done all these good things with the poor and the homeless and volunteer work, but are there people out there, have you done this any other time, when we don't have a record in the same vein as this contempt?
I'm so happy you asked that question, Judge. I go out of my way not to tell people I'm a judge, nor do I ask for any favors. When I talked to Mr. Britton Henry, I said, do not treat me as a judge. And I think that's probably my best theory on my incredibly poor judgment is it was a debt that I owed 3 years before I was a judge. We're going back 8 years. My daughter was in 8th or 9th grade. She just graduated college. So the debt was incurred 3 years before I became a judge. As I did with my staff and as I did with this, I'm actually doing what you want me to do. I was acting like I wasn't a judge. And I was basically saying, the hell with you. We didn't go to the club that year. My daughter fractured her spine. Why should I pay if we didn't even attend for that year? I don't owe you the money. So I was actually, I wish I was being more judicial because I probably would have handled it a lot differently. I was handling like a civilian moron and not a judge. And I sometimes had that problem of realizing I'm a judge because in my mind, I'm everybody, like I'm a reasonable lawyer, person, father, advocate, community service member. And I don't think of myself as a judge often enough, which is crazy as we hear people have black robe syndrome. I'm actually the opposite. I need to be more judicial. And I think my best theory to you and your colleague was the reason I handled this way because I didn't put myself in a position as I'm a judge and this reflects on my colleagues. I was putting myself as I owed this from 8 years ago. These people are, you know, trying to collect a debt I don't owe. And I could have just paid it. There are so many errors I made along the way that we would have to have a whole nother hearing to tell you about.
Any other questions for Judge DeClaudio? Seeing none, Judge, you may step down. Not excused, but step down.
Thank you all for listening. And I apologize I couldn't give you the answers because sometimes there just isn't a good one. So thank you. Excuse me.
Judge Eisenhower?
Mr. Stretton, I thought we had stipulations on admissibility of exhibits.
I just want the record to reflect that I believe we do. 1 through 57, 1 through 52 are the character letters that were sent about a month ago. And 53 through 57 are the productivity charts and the articles of community service. And then 59 through 63 were communication back and forth with the board during the 2020 time period before I became involved. So I just want the record to reflect that I'm moving those exhibits into the record if there's no objection.
Any objection, Ms. Norton? Can't hear you.
Oh, thank you.
No objection, Ms. Norton, no objection.
No, Your Honor, at risk of sounding like a nitpicker, I have an objection to one and only one exhibit, and that's R36. And my objection is on the document. And at the very top, there's some tiny handwriting that says it's Matt Riley, but I just feel it's my duty to object to the omission of that single exhibit because it doesn't self-identify itself, and I have no way of knowing who it's from.
R36 is from attorney Matt Riley, but I have no objection to that being excluded.
All right, we'll exclude is it R36 or R37, Ms. Norton?
It's R36.
R36 will be excluded. The other exhibits referenced by Mr. Stretton stipulated as admissible by Ms. Norton will be admitted into the record.
And with that, we would rest our case in behalf of Judge DeClaudio.
Okay.
Okay, I think we're ready for summation. Ms. Norton for the board.
Thank you, Your Honor. May it please the court. I'd like to begin and I will be brief, Your Honors. I noted that Judge Eisenhower asked about how Judge DeClaudio today, how he would handle attorneys who don't appear in his courtroom or might appear late. And actually, we have an example of how he handles that in Exhibit R22, which is a letter from an attorney named R. Patrick Link. And when you get the opportunity, judges, I suggest you look at the second page of that letter, because R. Patrick Link tells you that, I'll quote, "There was one occasion where I was regrettably late for his," meaning Judge DeClaudio's, "courtroom. As a result, he punished me by ordering to attend community service at his MANA program he was running." So there you have your answer, Judge Eisenhower. Although Judge DeClaudio gets held in contempt 3 separate times on a civil suit, when somebody shows up late in his courtroom, he punishes. Now, before I get into the heart of my very brief argument, with the court's indulgence, there are 2 matters from respondent's reply brief that was recently filed that I would like to address. And he talked about it today. And that's that essentially he's telling you part of the reason, or the reason, for his delay in responding to this court was the pandemic. And just briefly, I would point out to you that if you look at his Exhibit R63, it's also Board Exhibit M. You'll see that Judge DeClaudio, on June 5th of 2020, he sent an email to Attorney Metz. I would also point out to you that although he's telling you the reason he failed to respond to you as a court is because of the pandemic, he admitted today that during the entire period of time, he had email. He said that. I have email. I think that his excuse today and in his reply brief of the pandemic is disingenuous. I would also remind you that the reason Judge DeClaudio gave you during his pretrial conference, Judge Eisenhower and Judge Schwartzman, for his failure to respond to you was due to depression. He didn't utter a word about the pandemic. The other issue I would briefly address, and this is possibly just a matter of personal pride, from Judge DeClaudio's reply brief, he indicates that he had multiple communications with me during the period of time he was ignoring this court. I would indicate to you that he had 2 communications with me. You have evidence of the one. That was on December 31st of 2019, days after the complaint was filed. He called me and asked if I would agree to an extension of time for him to file a response with this court, something he never did. I followed up with a confirming email to him, confirming our phone call. There was one other occasion that you until now are unaware of that he called me, and that was on March 9th of 2020. And what I can tell you is on that occasion, the judge called me to tell me he had hired attorney John Summers. I memorialized that for just a memo for our file, and I will offer that to the court as an exhibit to this summation. And in that, I believe, can we show that to the court at this time?
Any objection, Mr. Stratton? Has Mr. Stratton seen the document?
No, he is not, Your Honor, because I was unaware how his client would testify today regarding
All right, well,
these live phone calls.
let him have a chance to read it and see if he has any objection to its admissibility.
I have no objection.
The point here,
Objection.
Before you do, Kim, let me read it, please.
The Judge DeClaudio wants to look at it a second. If I could just have a second. Judge,
Sure.
Here and to the shoulder.
Let me read it before it's me, please.
I'm just going to read it to him so he doesn't have to walk back. Remember, I corrected during Judge DeClaudio's testimony my misstatements in my reply brief that Ms. Norton wasn't communicating with us. But it says, his attorney, John Summers, will probably enter appearance by the end of the day tomorrow. This is dated March 9th, 2020. Attorney Summers is checking to make sure he does not have a conflict because he represents the DA in an unrelated matter, and the DA has requested Judge DeClaudio's recusal in an unrelated matter. Judge DeClaudio said he has an appointment with Attorney Summers tomorrow at 3 p.m. Judge, I'm going to not object.
That's fine.
I have no objection to that. And sorry to interrupt with the argument.
Ms. Norton, what will this exhibit be marked?
I think we could mark it Exhibit O because my last exhibit in my sanctions memo was Exhibit N, if that works for the court.
All
Now,
right.
I don't
Without
want to
objection,
belabor. Thank you, Your Honor.
Exhibit O is admitted.
Excuse me?
I said, without objection, Exhibit O is admitted into the record.
Thank you, Your Honor. I don't want to belabor this point. I will just say my point is I did not have communications that I did not relay to the court when I gave you my sanctions memo indicating that Judge DeClaudio had ignored you. But even more importantly than whether or not he communicated with me is the fact that he wasn't communicating with the court from the time the case was filed. In a disturbingly similar manner to the way he disrespected the Court of Common Pleas of Montgomery County. Now, thank you for your indulgence on that matter. Just getting to the heart of my argument. As the court is aware, I filed on behalf of the board a sanctions memo at the end of May that was filed. In that memo, I made an effort to review the 10 factors that this court has in the past used to determine what an appropriate sanction is. I'm not going to take this time to go back over my sanctions memo. Certainly, if the court has questions, I will attempt to answer those questions. But what I'd like to use this time for is to talk to you about what I will just kind of loosely call an 11th factor that this court should look at when determining an appropriate sanction or sanctions for Judge DeClaudio. And that 11th factor is essentially, please look at the amount of evidence that you have of Judge DeClaudio's complete disrespect for the law, his disrespect for the judicial system, even his disrespect for his own judicial seat. You know, and let me back up a moment and say, you know, we heard testimony from witnesses, and you certainly have received plenty of letters from witnesses telling you what a great judge he is on the bench. But I can't help but want to remind this court of what our Supreme Court told us back in 2013, and it was in the matter of, it was in Ray Carney. And in that case, what the Supreme Court said was, a judge cannot expect to be a rogue in his private life without staining the judicial position that he holds. And that's what we're talking about here. We're talking about a judge who, yes, half of his job is on the bench, half of the expectations the public might have for a judge involves his on the bench conduct. And it seems as though we have a judge that can handle a lot of work, and that's commendable. But the other half of what the public can expect from the judiciary is that off the bench conduct. And I can't imagine seeing more of a rogue judge when you look at his conduct off the bench. So back to my idea of this 11th factor. Let's look at the evidence of disrespect that you have in this case. You know, first of all, you have evidence of disrespect in the two factual scenarios that appear in the board complaint. That would be in the Kinwood Club lawsuit. I don't want to keep beating that matter, but it's interesting that we've had so many excuses by Judge DeClaudio for his failure to respect the Court of Common Pleas of Montgomery County, his failure to respect the law, the process, the attorneys, the judges. You know, he ultimately did go to court. On October 24th, 2019, he finally responded to that lawsuit that had begun prior to him becoming a judge. And I would submit to you that it's not a coincidence that October 24th fell just a few days after the day of October 19th, when he appeared in the Judicial Conduct Board offices for a deposition. After that, he decided it was time to go to court and respond to the Kenwood Club lawsuit. And then I'd ask you to look at, and you have it as an exhibit, the transcript, which shows you more evidence of his disrespect for the court, for Judge Burton in Montgomery County. If you read that transcript, you will see throughout the transcript, he's weaving in excuses for his disrespect for the court, for his failure to respond. He tells Judge Burton he thought the case was going to be settled. He tells him that he thought the debt was discharged in bankruptcy. He told them that he didn't receive notice, some or all of the notices. He told him that his judicial secretary was supposed to have continued one of those hearings. That's not respect for Judge Burton, to go in there and then give more excuses. And I would also note for this court that today we heard another excuse, and that was simply that he ignored it. He ignored it. The other very clear evidence this court has of my 11th factor, that he disrespects the system, let's just call it, are the statements of financial interest. Now, I will freely admit that if the only thing we were looking at with Judge DeClaudio was that he had filed 4 inaccurate statements of financial interest, and that a day after he was deposed by the Judicial Conduct Board, he saw the light and amended those statements of financial interest. If that were the case, we probably would not be here. But that's not really why that matter was on the board's complaint. That matter is on the board's complaint, not only because it's misconduct, but because it paints a very clear picture of how this judge conducts himself off the bench. That 50% of what the public expects of him, it's careless. It is rife with complete disregard and disrespect for the rules that he is bound to follow as a judge. And actually, the rule that requires judges to give an annual statement of financial interest, that's a Supreme Court rule. That's not just anybody saying, hey, the public saying, hey, we want to see your statement. That's the Supreme Court. And you know what he did with it for 4 consecutive years until the Judicial Conduct Board pointed it out to him? He filled it out carelessly. And I know most, if not all of you, have seen these forms. It's a 1.5-page form. It asks 13 simple questions. One of those questions, I think it's question 8, says, list the creditors to whom you owe in excess of, I think the amount is $6,500. And I believe it says lists the interest rate of the debt. My point with that is, it's a simple question. And even if you are disposed to believe that Judge DeClaudio truly did not understand, as an experienced attorney and now judge, that the question saying list a creditor might include the IRS and the Department of Revenue as a creditor, even if you believe that that's reasonable for him to not be sure, how do you explain the fact that for a Supreme Court order, he does nothing to determine what that word creditor might mean in fulfillment of his obligation to the Supreme Court and to the public? All he would have had to do, Your Honors, is pick up the phone, call another judge. Hey, do you think the IRS is a creditor? Or pick up the phone and call one of those many attorneys that we heard from today and from whom you have letters. Hey, is the IRS a creditor? Or even the AOPC. Those violations are there for you to consider as violations in and of themselves, but probably more importantly, for you to consider as more of the evidence of this 11th factor, his total disrespect for his position, the rules that apply to his position, and in this case, a rule from the Supreme Court. So while I'm talking about the evidence of disrespect that we saw on the complaint, we also today heard more evidence of his disrespect, in this case for the Supreme Court. Because you heard testimony from the board's witness that, now, I do want to correct one matter. The board's witness and the board told this court that that discipline from the Supreme Court occurred on December 10th of 2015. While the proceeding was going on, Chief Counsel Long was able to confirm that although the court order is dated December 10th, 2015 from the Supreme Court, the proceeding itself did occur in March of 2016. So I do stand corrected. The proceeding occurred in March of 2016. That doesn't change what that testimony today showed you. It's more evidence of his total disrespect for the rules of the Supreme Court as far as statements of financial interest are concerned, and disrespect for the procedure, for the proceeding that he was in. Imagine being publicly censored for your attorney misconduct in a packed courtroom. And when it's done, you don't even get out of sight of the Supreme Court justices. You walk to the back of the courtroom and joke about it. I would submit to you that that is very strong evidence beyond the board complaint of his complete disrespect for 50% of his job, 50% of what the public has a right to expect of him. Finally, Your Honors, in this 11th factor, I don't think, I would ask that the court not miss one more point, and that is the timeline of the misconduct, the timeline of the disrespect, the timeline of the evidence of disrespect. What I'm trying to say to you is it was persistent, it was nonstop from before he was on the bench, right up through the filing of the complaint, and past that, right up until the point he hired Attorney Stratton. You see one act after another that shows you his disrespect for at least 50% of his job, disrespect for the judiciary. And I just review them briefly. What you see is even before he's on the bench, he's ignoring the Kenwood Club's lawsuit when it was filed in the Magisterial District Justice Office. He gets a default judgment. Okay, but sometimes that's a strategy. I understand that. But then he's a judge-elect, and he's still ignoring it. And he can't give you an excuse that he didn't have notice of it, because let's not forget, he filed the notice of appeal in the fall of 2015. He knew darn well that proceeding was occurring. Telling Judge Burton, as he did, that, oh, he didn't have notice of certain things is simply not credible. He's the one that filed the notice of appeal. So it begins before he's even on the bench, his evidence of disrespect for the system. It continues while he's on the bench. You have several areas of evidence of that disrespect while he's on the bench. He's ignoring the Kenwood Club lawsuit. He's being held in contempt of court, not one, not two, but 3 separate times, and never obeyed those court orders until after he appears in front of the Judicial Conduct Board. Not only that, he's found to have he's the recipient of private discipline from the Judicial Conduct Board during that period of time for his misconduct. And I would note for this court that Judge DeClaudio's statements that initially to you, that private discipline had to do with the way he was relating or his relationship with his staff, was a far cry from what he explained to you in cross-examination. He made some inappropriate remarks, used some nicknames for his staff. It's far beyond the way he related to his staff, far beyond having been too friendly with his staff. That's the continuing nature of his misconduct, of his disrespect, excuse me. It never stops. And even while he's a sitting judge, I've said he's ignoring the lawsuit, he's getting private discipline from the Judicial Conduct Board. He's ignoring you. We file a lawsuit or a complaint and he ignores you. It's continuing disrespect. I don't think I would ask that this court not ignore that evidence. Look at that as an 11th factor in this matter. Your Honors, in thinking about and deliberating on what your sanction or sanctions might be, on behalf of the board, I would ask that you attempt to craft a sanction or sanctions that would do 3 things in this matter. The first would be to somehow restore and maintain the public's trust in this judge, restore and maintain the public's trust in the judiciary, because you've found that his conduct has brought the judicial office itself into disrepute, and restore and maintain the public's faith in this system of discipline. That's number one. Number two of what I would hope the sanction would do is to impress upon Judge DeClaudio the serious nature of his misconduct. Because as we know, the Supreme Court's efforts to reprimand him through a censure did not impress him. It is my hope that this court can craft a sanction that will impress him on this occasion, this second chance. And lastly, Your Honors, and this is probably the hardest, the board, through me, is asking that you manage to craft a sanction that will prevent future misconduct by this jurist. Thank you, Your Honors.
Thank you, Ms. Norton. Mr. Stratton.
Thank you. I have a different view from Ms. Norton. I have a high regard for her, but her argument is more arguing the facts and is not looking at really the nature and purpose of discipline in this particular matter. It also is getting us in areas that I contend should not be considered. But let's just go through it. What are we doing? I first reject any suggestion that he showed disrespect for this court after the petition for discipline was filed. As you know, and as he testified, there was a virus. It did slow things down. It created many problems. He doesn't have to answer the complaint. I many times don't answer the complaint on behalf of judicial officers. He had a trouble getting an attorney. As you can see, he settled on Attorney Summers, but then as you see from the exhibits that we presented, he was not able to afford Attorney Summers in these particular matters. At the end of the summer of 2020, he hired me, and after that, we have moved forward and showed all due respect to the court. I just don't see that as any suggestion of disrespect or failure to fulfill his duties. Second, in terms of this case, as you evaluate discipline, and I am going to discuss the 10 factors that have been set forth for many years by this court to consider, I also think that they should be broadened, but not in the way that Ms. Norton has said. If factors do not adequately consider the many wonderful things that a judicial officer has done, and in reality, this court needs to do what the attorney disciplinary system did years ago, is define the nature and purpose of judicial discipline. It has never truly been defined. Years ago, in an attorney disciplinary case, Office of Disciplinary Counsel versus Lucarini, I convinced the Supreme Court to take a different approach. Our Supreme Court in attorney discipline wanted to take our Office of Disciplinary Counsel back in 1982, wanted to take a very punitive approach to attorney discipline and make it primarily punishment. And if certain types of misconduct would be disbarment, things of that nature, like New Jersey does with misuse of funds. Our Supreme Court in Lucarini disagreed with that, said the purpose of attorney discipline is not punitive in nature, but to protect the public from unfit lawyers. And every case has to be reviewed individually. I think there's a need for this court to adopt a similar rationale in judicial discipline, that it's not a punitive purpose as Ms. Norton and her office is calling for. It is a very different approach. It's an individual approach that looks at the entire person. Now, if we look at the 10 factors that our courts have allowed, I contend on balance, and if we look at the case law, discipline should be a censure or a minor suspension at most. First factor is isolated instance of evidence of pattern of misconduct. There is no pattern of misconduct. There is one civil lawsuit that he acted badly on, and it fits the category of only a fool represents himself in these matters. And that is a consideration. And in this particular case, there is no pattern. The situation with the staff is a minor matter, minor discipline, letter of counsel, and it was resolved. The nature and frequency of the occurrence of the misconduct, there is no frequency or occurrence. What was happening in this case was one civil suit where he acted badly. There is no other suggestions or anything of that nature that should be considered. The third is whether the conduct occurred in or out of the courtroom. As you know, this court takes a very strong position if misconduct occurs in the courtroom. And this was not in Judge DeClaudio's courtroom. This is a private matter, and his misconduct, though not showing up, had nothing to do with that factor. The fourth standard is whether or not the conduct occurred in the judge's official capacity or his private life. Clearly, this was in his private life in this matter. The fifth standard is whether or not he recognized and acknowledges the act, and he does. He said it repeatedly. We have stipulated to it. He has said he's sorry. He has expressed remorse, and that is a major consideration. The sixth factor is whether he's evidenced effort to change or modify his conduct. Well, clearly he has. He went through a difficult time with his divorce. He is now acting in a very excellent fashion as a judge in this matter. He has changed his life. He's accepted responsibility and has indicated this will not happen again. The seventh factor is the length of service on the bench. He's been on the bench 5.5 years. He's a young judge in these particular matters. The eighth factor is whether or not there have been prior complaints about him. Well, we had the letter of counsel, and that is the extent of it, and that was minor discipline. The ninth factor is the effect on the integrity and respect for the judiciary. This court found him in disrepute, so obviously I can't argue beyond that, but this was a minor matter. He shouldn't have acted that way, and he's expressed sorrow, and he's acted in a very positive way since that particular time period. The 10th factor, as this court knows, is did he exploit his position for personal desires? The answer is no. So if you balance and look at these factors, and then we're going to add some factors I'd ask this court to factor right in the future, the balance is that it's a relatively minor matter in his personal life that he acted like an idiot over. He should have had counsel. He acted badly. He is sorry about it. He settled the case, paid about 5 times more than he would have had to if he hadn't, and he has moved forward with his life in this particular matter. And these are issues that this court should consider. But then this honorable court ought to look at other factors which aren't within those. What kind of judge is he? How did he act? It is unanimous. And I heard no opposition, no adverse character witnesses as to how he currently runs his courtroom. He runs his courtroom in a magnificent way. He handles a huge volume of cases, but does it in a very personal way, in a very caring way on these particular matters. Every lawyer, in the letters, people have testified, have indicated what a fine judge he is and how it has affected the whole system and made things better and how he's helped many people in that. And he's moved more cases than any judge there. His productivity record is off the charts. And he's been given more responsibility by the Court of Common Pleas. So we know that he has performed his judicial duties very well and accepts responsibility and has done very much in handling his judicial responsibilities to not only make amends for his idiocy in that civil suit, but at the same time show that he has a high regard for his judicial position and is attempting to demonstrate that through the way he runs his courtroom in a very professional but very fair way. And there's no dispute that he does that. It is overwhelming, the evidence in this particular matter. But none of these are really considered when you look at the nature of discipline. because the nature of discipline, as this court's defined, has always been based on the punitive aspect of these matters. So I want to talk about some of the cases, but I also want to just take a couple points. I disagree, as I said earlier, with Ms. Norton, who I have a high regard for, with her suggestion that there is issues in terms of the prior matter and that his personal life is a mess. His personal life is not a mess. He runs it very responsibly. Yes, he misused that suit. And he agrees with that and accepts responsibility. But everything else he does shows to the contrary what a true person he is. And they ignore that. Second, the suggestion by Attorney Goldstein that he was flippant just belies the record. Judge DeClaudio indicated that it was while he was a sitting judge. He had to go back to the courtroom. He explained the circumstances. He said he didn't act disrespectful. He saw Mr. Mitchell as a reporter for the Legal Intelligencer, the Philadelphia legal paper, and said something to him. Now I'm going to go back to my courtroom or something to that effect. Mr. Goldstein seemed to think otherwise. But Mr. Goldstein's testimony has to be taken with a grain of salt. Supposedly this case ruined his firm's reputation, yet he's filing and alleging false allegations about Mr. Trump's having an election stolen, filing 3 different lawsuits, and he believes that is Mr. DeClaudio who's raised that. There's no indication that Mr. DeClaudio said anything publicly about that particular matter. So Mr. Goldstein, although he did the right thing initially in reporting the matter, and I take my hat off to that because I think lawyers have to do that in this current system, he has lost his good judgment in terms of evaluating this case, and I suggest his comments are unfair under these circumstances, and this court has to look at it more objectively. As to the statement of financial interest, there's no question that that was wrong. He corrected that as soon as it was brought to his attention, within 24 or 48 hours. Remember, in the original motion we filed back in last year, when we were arguing over whether or not there was going to be disrepute, disciplinary counsel or judicial counsel sort of said that's really not important, the statement of financial interest, because they cited the cases that we have of In re Horgus, which was the old 1996 Court of Judicial Discipline case, and also the old case of Judge Cervera, who I knew very well when he was sat on the common pleas bench. Both of those cases essentially said statement of financial interest, and Cervera, he was a Rufus judge. I'm very familiar with that because I represented a number of the Rufus judges, including Kenny Harris, during those years in the 1980s for the Court of Judicial Discipline and also in federal court. But Cervera wouldn't refuse to answer a question about whether he got a gift from whoever, I guess it was Tom Moore or Tommy Brown, who was handling the money up. He refused to answer that. The court was upset with him. In Horgus, he had not accurately provided income from his estate and will and bequest and things of that nature. But when you read Horgus and you read the language before that in Cervera, Horgus, a Court of Judicial Discipline, Cervera, a Supreme Court, they essentially said you can correct that. If you correct it timely, that is acceptable and seemed to suggest a major role. So how do you evaluate this kind of conduct here? The conduct was wrong. He accepts responsibility, but he's done so many wonderful things. That's the balancing. That's where you got to look now at the 10 factors, but what has he done? And what would harm to the system if he was suspended or removed? It would be a tremendous blow to the Philadelphia system, since he has a huge productivity level that is needed for that system. And there's been no testimony to the contrary, and the records I produced clearly show that. It's unrefuted. So what happens is we have to define what is discipline. Is it punitive, as Ms. Norton's suggesting? And I don't know where she's heading, but it sounds like she wants some severe discipline. I suggest it's not in this particular matter. It is very different, and the case law is very different. I reference this to the case I handled in re Missouri, which was decided 2 years ago. That was a case where a judge in his personal life acted very badly. The Judge Missouri, who was running for re-election, was betrayed by several of his friends. And those friends worked against him election day after telling him they were going to work with him. He was distraught. He was angry. He threatened them. He left threatening phone calls. He embarrassed them publicly on 3 separate occasions. And it was wrong. And this court understood that, though. And despite that, and despite the pattern, it was both the primary and general election, it gave him a reprimand with probation, and there was, in his case, some psychological matter. Or in Ray Tidd, someone I handled. Judge Tidd, of course, was acquitted of most of the charges. We had 10 days of trial. I represented him, but he was found in responsibility, as this court might recall, of coming into his office, yelling and screaming and threatening his staff because he found out they had filed complaints with the Court of Judicial Discipline against him as a district judge in that matter. And it's a serious matter to threaten staff when they're reporting you. But he got a reprimand because he accepted responsibility to some of that, had great character testimony. In Ray Brown, Judge Brown up in Sunbury, I represented him. He was very disrespectful to his staff over a 10-year period, often sexual comments. He had made comments about litigants, particularly minority litigants and women, and comments about their physique. He'd been on the bench 30 years in these matters. He retired, we worked out a deal, and he got a reprimand in these matters. So you have to look at the nature of discipline. It's not just, oh, we think he's bad here and we're out in uncharted territory. It is very clear this kind of conduct does not result in the kind of discipline of any serious sanction, suspension, or anything of that nature. Look at the case of Hamilton, the police chief. He got drunk at a party on the golf course and got into a fight and beat up the chief of police. This is the district judge. And even under those extreme circumstances, he got 9 months suspension and returned to the bench in this particular matter, in these matters. So there's ample cases where minor discipline is often given. And that's what we need to go back to and look at these cases. Change that in his interpretation of the rules of conduct in 2012 or 13, whenever the Carney decision was rendered. And you had cases like Judge Stolfus, where he was putting condoms in acorns and handing them out at judicial conferences to the public, things of that nature, to a number of women who were appalled at that. He had no discipline because it didn't apply. But again, his case was dismissed. I just want this court to get a sense of nature of discipline. In this case, I'd suggest if you take the overall view, which I'm asking you to do, and not take a microscope that Miss Norton is asking you to do, you see a very fine lawyer, a very experienced lawyer who's sitting in criminal court, where you see a lawyer who is doing many wonderful things and now has had the privilege of being elected as a judge. And as a judge, he has acted in a very responsible fashion. And as a judge, he's been innovative in how he works with his probationers and parolees. As a judge, he's given a lot back to the community, not only on his hard work on the bench and fairness, as all the lawyers have told you, both by letter or in person, but he also has done it by getting involved in community service, which the code recommends and asks judges to do. And by working with community service, meals, and bringing in probationers to assist, and that's helped them. You've heard his figures of like 1,200 or 1,300 probationers, only 5 or 6 in gun cases had reoffended during the last couple of years. That's because of the way he runs his courtroom. That's what we're dealing with. That's the kind of person you have to see. A very fine judge, very experienced, and who's doing wonderful things in the courtroom and on the bench acts in a very appropriate and very professional way. Now, obviously off the bench, he made a mistake in this case. But that's understandable sometimes. He got mad at them and let his anger fester, and it just didn't deal with it and just ignored it. It's a bad way of doing things, but it's not the end of the world, and he's sorry. And he did show up, and he did settle it, and paid like 10 times really the amount he would have owed if he had just paid it initially. He was wrong, but he accepts that, and he's not going to do it again, and he said that real clear. So That's what we're dealing with. And any suggestion he hasn't showed respect for this court is wrong. Just the way we presented this, briefs we filed, the arguments, the witnesses clearly show that he has respect for this court and is working hard at providing an entire record for this court to do justice. So, where do we stand? I suggest you, by the case law, that the appropriate recommendation should be discipline that allows him to remain on the bench and to continue what he's doing. If this court feels he needs a period of probation like they did with Judge Maruzak, we won't disagree with that. But there's no basis to make a punitive recommendation of a strong and sanction that might prevent him from continuing to serve on the bench. There is nothing here that would warrant that, and the case law, which I've cited in my brief, I'm not going to read every case, clearly suggests to the contrary. The judges who have done things that involve their conduct on the bench, such as Judge Berry got 4 months suspension for 12 years of running a business out of his judicial office, or Judge DeLeon got 3 months for finding someone, a friend in a bar, and then having taken that friend back and entering an order against the neighbor when there was nothing pending before him. Serious misconduct, but relatively minor discipline. Judge DeClaudio's conduct doesn't approach that in this particular matter. So I'm asking this court to evaluate the 10 factors and then define for the first time what is the nature of discipline. Be like Lucarini's decision. Define that it's not punitive in purpose, because that's what the Office of the Judicial Conduct Board is asking, and define it that it's to protect the public and protect the judiciary. And this record shows that Judge DeClaudio has made amends. His conduct has protected the public. His conduct has gained respect for the judiciary in this particular matter. So I'm asking this court to take a very different approach, but also redefine and also add factors on the 10 factors. So the 11th, 12th, and 13th factors are the good things the judge has done, the good character, things of that nature, which are totally left off when one does the traditional evaluation. Thank you. If there's any questions, but I'll be glad to answer them.
Thank you, Mr. Stratton. Ms. Norton, do you have any rebuttal?
No, I do not, Your Honor. Thank you.
Anything further? Any judge have any questions, concerns?
I don't have any questions.
Mr. Metz, do we have anything for us today? For the record, your microphone's off. Joe.
No, nothing further for the record.
All right. This hearing is therefore adjourned. We will repair to our room.
Okay.
Thank you.